Good afternoon to all of you. Okay. uh, Online students, can you all hear me? Kindly give me a confirmation. Okay, so today I'll try to cover another 100 questions. But before I proceed to that, I just want to make a correction in the previous thing. Please come to question number 300, the previous question that you have discussed yesterday. I think I just failed to look into a particular point. I think overlooked this area. Have you all come to question number 300? Okay. Online students, can you hear me? Okay. So please come to question number 300. With reference to the Indian judiciary, consider the following statements. A retired judge of a Supreme Court of India can be called back to sit and act as a Supreme Court judge by the Chief Justice of India with the prior permission of the President of India. That is true. There is no problem in that. Come to statement number 2. A High Court in India has a power to review its own judgment. Well, if this is a statement, the statement is right. A High Court has a power to review its own judgment. Because although the High Court does not have the power under the constitution, but there are various laws that is enacted by the parliament give this power. So therefore, the High Court does not have any power to review its own judgment as per the constitution, but through the ordinary laws. But the statement is saying a High Court in India has a power to review its own judgment as the Supreme Court does. The Supreme Court has a power to review its own judgment, but for the Supreme Court the power is coming from the constitution of India. So when you say as the Supreme Court does, because the Supreme Court is getting the power from the constitution, but that is not the case with the high courts. So therefore, the statement B should be wrong. Okay. Article 137 of the constitution. In the last class I have discussed that. Were you there in the last class? Okay, so last class I have discussed that. Under Article 137 they have the review powers. Not only the review powers, we have also seen that the Supreme Court has got the curative powers. But although the curative powers are not explicitly mentioned in the constitution, only the review powers are explicitly mentioned in the constitution. Alright, so please make a note of that correction. Online students, I am sure that you also make a note of that particular thing. So in general, if a question comes, does the High Court has got the review powers? Yes, but not as the Supreme Court does. But if a question comes as the High Court has the review powers under the constitution, then it is no. Is that clear? Okay. Sometimes it is better to make mistakes so that we remember that. So if you make it correct also, sometimes you again go and make a mistake. So making a mistake so that we will remember it, so that we are not going to make a mistake. Alright, so please come to the question number 306. Okay, consider the following statements. The High Courts can issue writs for the protection of both fundamental rights and legal rights. Yes, under Article 226 of the Constitution, the High Court has the power to issue, it's right. The High Court has the power to issue writs for the protection of both fundamental rights and the legal rights. But have anyone thought why the High Court is given wider writ powers than the Supreme Court in terms of the matters on which they can issue the writs? The Supreme Court is the highest court in India, but it has a power to issue writs only in case of what? Fundamental rights. Now, does it not look contrary? Well, the Supreme Court is the highest court, but its writ powers are less, because the Supreme Court cannot be burdened with ordinary legal rights. So it is the highest court which will look only into the important right, that is the fundamental right. Okay. The Supreme Court can be empowered by a law of Parliament to issue writs for the protection of legal rights. Is it possible? Yes. Under Article 139 of the Constitution, the Parliament is empowered by the Constitution. But no such law has been made by the Parliament till this point of time. But however, if in the future the Parliament wants to make a law, empower the Supreme Court to issue writs for the protection of the legal rights also, it can be done. But till this point of time, there is no such law. The judges of subordinate judiciary are appointed by the governor of the concerned state. Is it true? The judges of the subordinate judiciary are appointed by the governor. For the students who are coming late, I have made a correction in question number 300. Okay. So you can just check with the others, or if time permits, I will again discuss it in the end. So what is the answer here? Which of the statements are incorrect? So none is the answer. Please come to question number 307. Consider the following statements. The number of judges in case of the Supreme Court is determined by an act of Parliament. Is that true? So, who is authority to determine the number of judges of the Supreme Court? The Parliament, and it can be subsequently increased by a simple act of Parliament. The judges of the High Court may request to attend. A judge of a High Court may be requested to attend the sitting of a Supreme Court as an ad hoc judge by the Chief Justice of India with a prior consent of the Chief Justice of the concerned High Court. What about this particular statement? With the prior consent of the President of India. Okay, so therefore this particular statement is wrong. President? No, it is only in case of the retired judges the consent of both is required. So here you cannot call upon a judge of a High Court, a sitting judge of High Court, his consent is not required because he is still in the service. If a retired judge is called upon, then only the consent of the President and the consent of the retired judge is also required, not in this particular case. The Supreme Court has got original jurisdiction in all civil and criminal matters. Is it true? In fact, they have no original jurisdiction in criminal matters, so this is not possible. And in certain civil cases, they may have original jurisdiction, not in all the civil cases. So, anyways, this particular statement is wrong. So, how many of the statements given above are incorrect? 2 only. Did we discuss this question earlier? Okay, maybe it. Which way? Okay, Supreme Court. Okay, Supreme Court has got original jurisdiction. So, Supreme Court also does not have original jurisdiction. It is same for the High Court also. The Supreme Court also does not have original jurisdiction in any of the civil as well as in the criminal cases. So, anyways, this particular statement is wrong. So, what is the answer here? Which of the statements given above are incorrect? Incorrect, 2 only. A judge of High Court may be requested to attend the sitting of a Supreme Court. That means here a judge of High Court means a sitting judge of High Court. Can he be requested to by the Supreme Court? Yes, he can be requested by the Chief Justice of India, but with the consent of whom? With the consent of the President of India, not by the Chief Justice of the concerned High Court. Consultation is different, consent is different. Permission is what is consent. Okay, so therefore the consent is always from whom? From the President of India in this particular case. Okay, so come to the next question. Who shall determine the salaries and allowances of the judges of the Supreme Court? What is the answer? It is the Parliament who shall determine the salaries and allowances of the judges of the Supreme Court. Who is authority to empower the Supreme Court of India to issue writs for the protection of legal rights? The Parliament. We have already seen this under Article 309 of the Constitution. Who shall make rules for regulating the general practice and procedure of the Supreme Court? What is the answer here? Can anyone tell me? Is it the Supreme Court, the Chief Justice of India, the President of India, the Parliament? What is the answer? It is the Supreme Court. It is not the Chief Justice of India. Article 145 of the Constitution is giving the power to the Supreme Court, not to the Chief Justice of India. Okay, is that clear? So, therefore, the Supreme Court has got a Supreme Court committee for this particular matter, which is headed by the Chief Justice of India and the other judges. But the authority is only with the Supreme Court of India, and that is exercised by a committee on behalf of the Supreme Court. So, as per the Constitution, the right answer is the Supreme Court. And which article says is Article 145 of the Constitution. How many of you got this right? How many of you thought it is Chief Justice of India? It is the Supreme Court. Which article confers a contempt powers upon the High Court? Article 215, and for the Supreme Court it is Article 129 of the Constitution. Try to remember certain articles. So, in this case it is Article 215, but is the term contempt defined in the Constitution? No, it is only the Parliament which has made a law and defined contempt. And in fact, the Contempt of Court Act, which was enacted by the Parliament, classifies contempt into civil as well as criminal contempt. Alright, so contempt is an item in the union list, so therefore who will have the power to make law? Only the Parliament will have the power to make laws in this regard. So, this is a very important area. Who is authority to transfer the judges of the High Court as per the Constitution of India? Who is authority? president, but on the recommendation of the collegium. And who constitutes the collegium here? Chief Justice of India plus 4 senior most judges, but you should be aware of the procedure also, because recently a judge from the Delhi High Court is transferred to the Uttar Pradesh High Court. Now, what is the procedure to transfer a judge of High Court? The recommendation is given by the collegium, where the collegium consists of Chief Justice of India plus 4 senior most judges. But however, before this collegium gives a recommendation to the president, the collegium in turn has to make an internal consultation. So, whom they have to consult? They have to consult the Chief Justice of the concerned High Courts. Okay, so whoever is the Chief Justice of the concerned High Court, they may be consulted, and after getting a written recommendation from them, then only they can give the report to the President of India. That then only the collegium can make the recommendation to the President. So, therefore, in this case, whose authority as per the question? It is the President. Consider the following statements. Statement 1, the High Courts have the power to issue writs for the protection of the High Courts have the power to issue writs for the protection of both fundamental rights and legal rights, whereas Supreme Court can issue writs only for the protection of fundamental rights. What are the relevant articles in this question? Article 226 and Article 32 of the Constitution. So, these are the relevant articles. The High Courts shall have the power of superintendence over all the courts and tribunals throughout the territory of India, which it has jurisdiction without any exception. That means, if a High Court is having jurisdiction over the territory of the entire state, that means will it have the power of superintendence over all the tribunals and all the courts, which is the power of the High Court under Article 227. Is it correct or wrong? So, what is the key word in this particular statement? Without any exception, making it as an extreme statement. And what is the general rule when it is an extreme statement? Mostly it is wrong, but it can be right also. So, whether here it is right or wrong, that is the question. Without any exception. So, does the High Court have power of superintendence over all the courts, all the tribunals within the territory of that particular, wherever it is having a jurisdiction? So, for example, if it is a Madras High Court, it will be the state of Tamil Nadu and the Puducherry, because both the areas it has got jurisdiction. So, can this statement be seen as true? The High Court does not have jurisdiction over the Armed Forces Tribunal. If an Armed Forces Tribunal is there within its jurisdiction, there it does not exercise any power of superintendence. Therefore, an extreme statement here is wrong, because there is an exception to this. Okay, so in general, if they ask, will it have jurisdiction? Yes, but if it is asking without any exception, then that is not right. Is it clear to all of you? What is the answer here? Which of the statements given above are incorrect? So, it is option 2 only. Consider the following statements. The salary, allowances and the pensions payable in respect of officers and servants of the High Court are charged upon the consolidated fund of the state. Is it true? Why? It is not for the judges, it is for the officers and servants of the High Court. So, judges are different, officers and servants are different. It is only for the judges of the High Court, their pensions are charged upon the consolidated fund of India. But in case of officers and servants, their salaries, their allowances, their pensions, everything is charged upon the consolidated fund of the respective state. So, this is exactly, I thought the student will make a mistake, so I have made a mistake. So, officers and servants are different, the judges are different. Is it clear to all of you? So, in this case, is it true or false? Yes. So, this particular statement is true. The Parliament by a law can extend the jurisdiction of a High Court to any union territory. Is it possible? Now, these are all few important things that you have to remember. Who has authority to extend the jurisdiction of the High Court to any of the other places, to any of the other state or union territory? It is a Parliament. Who has authority to establish a High Court of its own for any union territory? It is a Parliament. Okay, so it is a Parliament which has got the authority for all these things. So, this is also true. Which of the statements given above are correct? What is the answer? It is both 1 and 2. Who has the power to establish a common High Court for 2 or more states? Parliament. Who has authority to establish a High Court for a particular union territory? Parliament. Who has authority to extend the jurisdiction of a High Court to an other union territory? Parliament. Okay. So, with that we are done with judiciary also. Judiciary you can expect one question. At the max probably 2 questions, nothing more than this has been asked. So now we are completely covered almost 10 to 12 questions. So now we will move to the next part, that is center state relationship. Again one question is the possibility. Okay, so quickly come to the center state relationship. One question is a possibility here. Consider the following statements. The Rajya Sabha alone has a power to declare that it would be in national interest for the parliament to legislate with respect to the matters in the state list. Is it true? Who alone has the power to do this? Only the Rajya Sabha. The Rajya Sabha alone has a power to declare. To declare, it is not having the power to make law. The law has to be made by the parliament, but on the basis of a resolution that is passed by Rajya Sabha. So which article is giving this power to the Rajya Sabha? Very good. Article 249 of the Constitution is giving this power to the Rajya Sabha. And what is the majority with which the resolution has to be passed by Rajya Sabha? What is the majority? But there are different types of special majority. So what is a special majority in this case? The special majority is not less than 2/3 of what? Present and voting. So whenever a resolution is passed by Rajya Sabha under Article 249 of the Constitution, how long do you think that this resolution will be in force? This resolution will be in force for 1 year, and within this period of 1 year the law has to be enacted. The law cannot be enacted after this. So within this time the law has to be enacted. Is that clear? And if the law is enacted within this 1 year time, how long the law can continue? Or in other words, if the Rajya Sabha passes a resolution and if a law is made by the parliament by virtue of Article 249, is this law a permanent law or a temporary law? This law is only a temporary law. Very good. This law is only what? It's a temporary law. So my question is, how long this law can continue if it is only a temporary law? This law can continue to exist only for a period of 6 months after the 1 year time is over. Is that clear? Come to the statement number 2. The resolution approving the proclamation of emergency are passed by the Lok Sabha. The resolution approving the proclamation of emergency are passed by the Lok Sabha is okay, but the question is passed only by Lok Sabha. It has to be passed only by Lok Sabha. In fact, any type of emergency, it has to be approved by both the houses of the parliament, not just only by the Lok Sabha. So therefore this is wrong. So which of the statements given above are correct? One only. Consider the come to the next question at 317. Which one of the following articles of the Constitution of India says that the executive power of every state shall be so exercised as to not to impede or prejudice the exercise of the executive power of the union? That means it is saying that the executive power of the state should not be in any way obstructing the executive power of the union. So that is what is this particular question. So which article is giving this condition in the Constitution? Article 257, not Article 256. Article 256 is only saying that the executive power of the state has to be carried in accordance with the law that is made by the parliament. It is not saying that it should not impede the executive powers of the union. Article 256 saying, however the executive power is carried out, it should be in accordance with the law. But Article 257 is specifically saying that the executive power of the union should not prejudice the executive power of the state should not prejudice the executive power of the union. Okay, so this is under Article 257 of the Constitution. So what is the answer here? What about Article 355? This is also again an important article. It is the responsibility of the center to protect the state from internal disturbance and also external aggression. What about Article 356? President rule. What is Article 258? Union can confer certain powers upon the states, but the state cannot do so. So union can confer some of its powers and the state can request the union also. Okay. So these are all some of the important provisions probably you'll have to remember. So please come to the next thing. Which one of the following articles of the Indian Constitution provides that it shall be the duty of the union to protect the state against external aggression or internal disturbance? Which article? Article 355. Very good. What about Article 215 in the Constitution? Contempt powers of the high courts. What about Article 275? The statutory grants that can be given by the center to the states on the recommendation of the Finance Commission. that is there in Article 275. What about Article 325 of the Constitution? Okay, so do you want me to repeat any area? Article 215 is related to the contempt powers. Article 275 is related to the statutory grants, granting aids that is provided by the center to the states. And the statutory grant is given by the center to the state on the recommendation of the Finance Commission. What about Article 325? That no one shall be discriminated when it comes to right to vote on the grounds of religion, race, caste, sex. So, in fact, Article 325 talks about no discrimination when it comes to right to voting. Article 355 is the internal disturbance. So, try to remember some of these articles also. Not many questions may come here, but you never know. Sometimes they can ask because each and every single question can make a lot of difference. So, that is why if I want to go easily, I can just say the answer and go, but I am giving an explanation so that it will also be a revision for all of you. The Parliament can make any law for whole or any part of India for implementing international treaties. Is it true? Yes. So, in this case, can the Parliament do without the approval of the state, without the consent of the state legislature? Yes. So, this is a power that is given to the Parliament, but such powers are not there to the state legislature. That is why we say that the entire Constitution of India is quasi-federal, or there is a federal supremacy under the Constitution of India. But which article is giving this power to the Parliament? Article 253 of the Constitution. So, here it can be done without the consent of any state. So, Article 253 of the Constitution is giving this power. Okay, now tell me, if a law is made by the Parliament to give effect to any international treaties without the consent of the state, will this law be a permanent law? Yes, it is a permanent law. This law is a permanent law. Okay, one of the questions from the online student is, what is the curative powers of the Supreme Court? We have studied about what is the review power of the Supreme Court. What is the review power of the Supreme Court? To review their own judgment. If there is any error in the judgment, they can review it. So, what is the curative power? There is no difference between review powers and curative powers. There is an extra option available on top of the review powers. You cannot directly go for a curative petition. On top of the review petition, still if you feel that the justice is not done, on top of the review petition, the affected individual can again file a curative petition. It is merely a procedural difference. You do not have to worry about the procedural difference. So, because the Supreme Court can make rules with regard to how the petition shall be filed in the Supreme Court. So, who has the power to regulate the rules with regard to how these things can be done? The Supreme Court itself. Just now we have seen. So, the Supreme Court has already made a rule on top of the review petitions, you can file what is a curative petition. But whenever a curative petition is filed to the Supreme Court, it has to be countersigned by a senior advocate, whoever is designated as a senior advocate. In other type of cases, petitions, it is not required. But when you go for a curative petition, because it is the highest level of petition, that is the last remedy that you have got in the Supreme Court. Therefore, it has to be countersigned by a senior advocate. So, who will designate someone as a senior advocate in the Supreme Court? Who will? The Bar Council of India has no authority in this regard. Because if the Bar Council of India is to do, then there is a clear conflict of interest. Because the Bar Council of India is of lawyers. The lawyers themselves cannot designate someone as a senior advocate. So, who is supposed to designate someone as a senior advocate? It is the Supreme Court of India who will designate the senior advocates of the Supreme Court. And the high courts of the states, they can designate the senior advocates practicing in the high courts. There is no hard and fast rule, but it is based on the standing of that particular council and how he is effective and how he is able to influence the judges. So, based on the respect that he commands from the judges, the court will honor them as what is called as a senior advocate. Okay, so without, okay, come to the next question. Consider the following statements. The federal disputes between the states directly fall under the original jurisdiction of the Supreme Court. Is it clear? Under which article they fall under the original jurisdiction? Article 131. What about a dispute between an union territory and a state? What about dispute between union and a union territory? What about the interstate river water disputes? Okay, it shall go only to the tribunal. The idea of having a body like an interstate council is to take up such matters and to resolve the differences without going to the courts. Is it true? First of all, you should know, it should not confuse us with interstate river water dispute. It is interstate council. And the interstate council can be established under which article in the constitution? Very good, article 263 of the constitution. Who will head the interstate council? The prime minister himself. If it is appointed, the president can appoint an interstate council, and the prime minister himself will head the he is the chairman of the interstate council. The interstate council is in fact the highest executive body in the country, but it is not properly functional. But if at all the interstate council is established, the chairperson will be the prime minister himself, along with 6 union cabinet ministers decided by the prime minister. And then apart from that, it will have chief ministers of all the states in our country, and apart from that, it will have chief ministers of all the union territories wherever there is a chief minister, and apart from that, it will have the administrators or the lieutenant governors of all other union territories. That means all the top executives will be part of the interstate council. So what is the objective of having such a body? Is to resolve the differences of opinion between the center and the states, or between different states, especially where there is a federal dispute. So therefore, to that extent, this particular statement is true. Come to the next thing, the zonal councils are statutory bodies established under the State Reorganization Act. Is it true? That is true. So under the State Reorganization Act, how many zonal councils are there? 5 zonal councils are there. We have a northern zone, central zone, we have a southern zone, eastern zone, western zone. Apart from that, we also have what is called as a northeastern council zone or a northeastern zone, but that is not established under the State Reorganization Act. It is established by Northeastern Councils Act. Okay, so therefore try to understand that. But however, this particular statement is true. It is established by a statutory body. It's a statutory body established by a statute. Here also the objective is the same. The objective is to resolve the differences at a zonal level. It's not at the all India level. But here who will head all the zonal councils? The Union Home Minister will head all the zonal councils, and the chief ministers of all the states will be part of it. Is it clear? So this is what we will have to understand about this. So what is the answer here? Which of the following is are correct? All of the above. Consider the following regarding the interstate river water disputes in our country. The interstate river water disputes can be challenged only in the river water tribunals that is established under the Act of Parliament. Is it true? So which article is providing for this particular provision? Very good. Article 262 of the Constitution is saying that in case of interstate river water disputes, they cannot go to the Supreme Court, although it is a federal dispute. Where they can go? They can go only in front of an authority as established by a parliamentary law. And the parliamentary law, what is a parliamentary law? Interstate River Water Disputes Act 1956, and based on which an ad hoc tribunal can be created whenever there is an interstate river water dispute. So therefore, this particular statement is true. The order passed by the tribunal is final and binding and cannot be challenged in the Supreme Court under any of its jurisdiction. So in fact, the law says the order that is passed by the tribunal is final and binding. But if the question is coming that it cannot be challenged in the Supreme Court under any of the jurisdiction, is it right? So can it be challenged in the Supreme Court under the appellate jurisdiction? What is appellate jurisdiction? Appellate jurisdiction is normally you are making an appeal from a lower court to a higher court. So tribunal is a lower court or an upper court to the Supreme Court. Tribunal is a lower court. So can we make an appeal against order of the tribunal? How many of you think that you can make an appeal? You can go to the Supreme Court, but not under the appellate jurisdiction. You can only go to the Supreme Court under the special leave jurisdiction under Article 136 of the Constitution, because the law explicitly prohibits the Supreme Court from entertaining these cases. But however, whatever is the law says is overruled by the constitutional provisions. And what is Article 136 of the Constitution is saying? Which is talking about the special leave jurisdiction of the Supreme Court, which is also called as SLP petitions. If you look into the SLP petitions or Article 136 of the Constitution, Article 136 of the Constitution says that even if an individual cannot go to the Supreme Court under any of the jurisdiction, still nothing prevents the Supreme Court from entertaining a particular case, from granting a leave to a particular case. That means accepting a particular case. So therefore, that is why it is called as an extraordinary jurisdiction of the Supreme Court. That means who will decide whether to accept the case or not? It is the Supreme Court. Nothing can prevent the Supreme Court from entertaining any case under the special leave jurisdiction. But who is the final authority to decide that? the Supreme Court of India itself. That is why even the Supreme Court has said that this power has to be used very sparingly by the Supreme Court, because it is an extraordinary jurisdiction. Now with that, come to the question. The order passed by the tribunal is final and can't be challenged in the Supreme Court under any of its jurisdiction. Is it true? False. But if the question is saying it cannot be challenged under the original jurisdiction, is it true? If the question is saying it cannot be challenged in the appellate jurisdiction, that is also true. But to say under any of the jurisdiction is a wrong thing. Okay. So what is the answer here? Which of the following statements given above are incorrect? It is 2 only. The Parliament of India acquires the power to legislate on any item in the state list. Under which article? So what is the answer? Okay, the Parliament of India acquires the power to legislate on any item in the state list in the national interest if a resolution is passed to that particular effect by what is the answer? By Rajya Sabha by not less than 2/3 of the members present and voting. Article is 249. Which one of the following is not a feature of Indian federalism? So which one of the following is not a feature of Indian federalism? An independent judiciary, is it a feature of Indian federalism? In fact, it is must to ensure what is called as federalism. So this is definitely there. Powers have been divided clearly between the center and the states. Has the powers been clearly divided? Is it divided? Then why we are calling it as quasi-federalism if the power is clearly divided? Quasi-federalism does not mean that the power is not clearly divided. It only means that more power has been given to the center. But whatever power that is given, that is clear between what is the power of the center and the states. Federating units have been given unequal representation in the Rajya Sabha. Is that true? Yes, the representation in the Rajya Sabha is based on population rather than equal representation. So this is also part of our federalism. It is a result of agreement among the federating units. It is not a result of any agreement among the states, but it is only a holding together federation rather than what is called as a coming together federation. Okay. So therefore, what is the answer here? It is option D. Consider the following statements. Under the constitution, the center can give directions to the state to ensure compliance with the law made by the parliament. Is it true? Under which article they can give directions? Under article 256. With regard to a law, they should ensure compliance, and if there is no compliance with regard to a law that is made by the parliament when it comes to the state executives, so the direction can be given under article 256. So therefore, is it right for any state to say that they will not implement the Citizenship Amendment Act 2019? So Citizenship Amendment Act is passed by the parliament, and some of the states protested that, saying that they will not implement this law. I am not getting into the merit of the law. Okay, let us not have a debate on the merit of the law. That is for the Supreme Court to decide. But some of the states said that they are not going to implement the Citizenship Amendment Act 2019. So is it constitutionally right for the states to say? Because the executive power of the state has to be exercised in accordance or in order to ensure compliance with the law made by the parliament. And in case if they are not showing compliance, then the center can give directions. Okay, you are not showing the compliance, so give the compliance. All these things can be done under article 256. Okay, once a direction is given under article 256, still if there is no compliance, then article 365 will come into effect. What is article 365? Then the president can come to a conclusion that the administration of the state is not carried out in accordance with the provisions of the constitution, that is as a constitutional breakdown. And if the constitutional breakdown is the situation, then article 356 kicks in. What is article 356? That the president rule can be imposed in a particular state. Therefore, under which article the president rule can be imposed in a particular state? Under which article the president rule can be imposed? 256, 365, 356. Under how many articles the president rule can be imposed? Under which article? Only one article, that is article 356. Okay, so do not have any confusion in this regard. It is only under article 356 the president rule can be imposed. So what is the answer in this case? Have we discussed it? Have we discussed this question? Under the constitution, the center can, okay, first statement, it is article 256. The states must share their revenues with the center as per the constitution, as per the recommendation of the finance commission, as per the constitution. Is it true? It is rather vice versa. It is only the center that has to share their revenue with the states, and not the states will share their revenue with the center, as per the recommendation of the finance commission. Under which article the finance commission is established? Article 280 of the constitution. So this is wrong. So which of the statements given above are correct? What is correct? One only. Come to the next question. Which of the following special powers have been conferred on the Rajya Sabha by the Constitution of India? Statement 1, to change the existing territory of a state and to change the name of the state. The Rajya Sabha has no power in this regard. It is a power of the parliament and not that of the Rajya Sabha. Under which article they can do that? Under article 3 of the constitution. To pass a resolution empowering the parliament to make laws in the state list and to create one or more all India service. Is that right? To pass a resolution empowering the parliament to make laws in the state list and to create one or more all India service. Okay, anyways, let me go to the other statement also. To amend the election procedure of the president and to determine the pensions to the president after his or her retirement. It is a power of again the parliament, not that of the Rajya Sabha alone. Okay, so what is the last statement? So while A and C are wrong, what is D? To determine the functions of the Election Commission of India and to determine the number of election commissioners. What about this? To determine the number of election commissioners is not even the power of the parliament. Who will determine the number of election commissioners? The president may determine that from time to time. But to determine the functions of the election commission, that can be determined by the law made by the parliament, a Representation of People Act. So anyways, this particular statement is also not completely right. So we are left out with what? We are left out with only option B. So here the understanding you should have is based on this particular statement. It is only saying based on the resolution that is passed by Rajya Sabha, the parliament can make a law. So, but who is empowered to make the resolution? For the parliament to make a law on an item in the state list and also to create a new all India service, it is the Rajya Sabha. Okay, so under which article the new all India service can be created? Under 312, sure, under article 312 of the constitution. So how many all India services we have presently? No all India service. How many all India service? 3 all India services are there. What are the 3 all India services? Indian Administrative Service, Police Service and Indian Forest or Foreign? Forest Service. Foreign Service is a central service. It is not an all India service. So if at all in the future new all India service is to be created, so who is authority to create a new all India service? It is a parliament, but based on the resolution that is passed by the Rajya Sabha. But my question is, why do you think that the Rajya Sabha has to pass a resolution to create a new all India service? Because creating new all India service means it is affecting the federal interest. So therefore the states have to give the consent to go for a new all India service. How do you think creating a new all India service will affect the federal interest? So therefore, if a question comes, which of the above are the federal features of the constitution? If the all India service comes, is it part of a federal feature? It is not a part of a federal feature. It is more unitary in character. Because all India services, once you will get into all India services, you will realize that though all India service officers serve in the states at the highest position, but the state government has no control over these officers. Who will have control over the all India service officers? The center. So therefore, it goes against the federal interest. Okay. So anyway, so what is the answer in this case? It is option B. So come to the next question. Consider the following statements. Only the parliament can make laws on the items mentioned in the union list. Is it true? It is always only the power of the parliament. So in this case, the extreme statement is right. No other authority will have the power to make laws on the items in the union list, which means, will the state legislature have the power to make law on the union list? No, it is only the power of the parliament. Only the state legislature is empowered to make laws on all the items in the state list under all circumstances. Is it true? It is not under all circumstances. Under certain circumstances, the parliament is empowered to make a law. Parliament is also empowered. So, can anyone tell me what are the circumstances under which the parliament is empowered? Article 249, when the Rajya Sabha passes a resolution in national interest. Okay, what is the other article? Okay, when two or more states pass a resolution, when two or more state legislature pass a resolution under Article 252. Anything else? Article 250 is related to what? Article 250 is related to president rule. Article 250 allows a parliament to make a law on an item in the state list when there is a proclamation of national emergency. But national emergency can be proclaimed under Article 352 of the Constitution. So, therefore, when a national emergency is proclaimed under Article 352 of the Constitution, then Article 250 comes into effect. So, Article 250 empowers a parliament to make a law on an item in the state list. Is that clear? So, this is while national emergency is in force. While the national emergency is forced. What are the other articles? Article 253 is to give effect to international treaties. And then the last thing is when there is a president rule in a particular state. When the president rule is imposed in a particular state, we know that the legislative assembly will be dissolved. Once the legislative assembly will be dissolved, who will make law on an item in the state list? The parliament will make law on an item in the state list. So, this is during what is called as president rule. Okay, one last question that I wanted to ask. Let me see how many of you are able to answer this correctly. The important thing is, in all these cases, whenever the parliament makes a law on an item in the state list, under what circumstances among all these things, under what conditions, if a law is made by the parliament, it would be considered to be a permanent law. Not in all the cases the law made by the parliament is a permanent law. Under what circumstances it is a permanent law? What about law made under Article 249? It is only a temporary law. So, this is temporary. What about law made under Article 252, two or more states? It is a permanent law. Very good. It is a permanent law. What about Article 250 during national emergency? Permanent or temporary? During national emergency, understand it is a temporary law. And how long this law can continue to exist? 6 months after the revocation of the national emergency. That is a maximum time. Okay, 6 months after the revocation of national emergency. Therefore, it is temporary. What about under Article 253? It is a permanent law. It's a permanent law. What about Article 356? Permanent or temporary? It's a permanent law. Okay, so here also it is a permanent law. So, but however, understand in this case, here it is a permanent law under Article 356. In this case, the state legislature is free to amend this law. So, when the new government is formed and when the state legislature comes, they are free to amend this law. But however, in this case, when I talked about 252, so in this case, the state legislature cannot amend this law. It is only the power of the parliament. Okay, so try to understand that. And to, any international treaties also, the state legislature does not have any power. Okay, so try to remember about all those things. So questions can come from any dimensions. Shall I move to the next question? So what is the answer? Have we completed the questions? Okay, one more statement is there. What about this particular statement? So this particular statement is wrong. Come to question number 3. Both the parliament and the state legislature can make a law on an item in the state list. However, in case of conflict, both the parliament and the state legislature, just make a small correction, okay, I made a mistake here, I think I just overlooked. Both the parliament and the state legislature can make a law on a concurrent list. Let me make it as a concurrent list. Okay, please make a correction. On a concurrent list, both parliament and the state legislature can make a law on an item in the concurrent list, but however, in case of conflict between these laws, the law made by the parliament will prevail in all cases. Yes or no? In all cases is an extreme statement. So therefore, extreme statement is correct or wrong? There is no general rule, but here is it correct or wrong? But 90% of the times you can, going by the UPSC language, not only for the subject polity, for other things also you can, if you want to attempt this, you go for a something to be negative if you are not aware of it. But in this case, it is right or wrong? It is wrong. It is not in all the cases. Why? What is the exception? Very good. If there is any conflict between the law made by the parliament and the law made by the state legislature, but however, if the bill is assented by the President of India, if the governor has reserved this bill for the consideration of the President and the President gives the assent to this particular bill, then the law made by the state legislature will prevail over the law made by the parliament. Is that clear? So, not in all the cases, sorry. So, what is the answer here? One only. Which one of the following doctrine is related to resolving the center state disputes? Okay, before saying the answer, what is this doctrine of eclipse? What is this doctrine of eclipse? Article 13 of the Constitution is saying any law, if it is in violation of fundamental rights, that law shall be declared to be invalid. But the question is, what if it is a pre-constitutional law? So, in case of a pre-constitutional law, the law will not be struck down from the statute, or any portion of the law which is violative of the fundamental rights will not be struck down, but it will be eclipsed by the fundamental rights. That is what is called as doctrine of eclipse. But however, if it is a post-constitutional law, which doctrine will apply? Doctrine of severability. Doctrine of severability means that portion of the law which is in violation of the fundamental right will be struck down, will be cut from the law. But whereas in case of a pre-constitutional law, it will not be struck down, it will be only eclipsed by the fundamental rights, or in other words, those portion of the law which is in violation of the fundamental rights will remain dormant as long as the fundamental right is there. But in the future, if the fundamental right is amended and therefore there is no conflict between the law and the fundamental right, and the law will automatically come into force. But that is not the case with what is called as a post-constitutional law. Now, why do you think that the doctrine of eclipse is followed in case of a pre-constitutional law, and whereas the doctrine of severability is followed in the post-constitutional law? Because when the pre-constitutional law was made, the fundamental right was not there in the first place. So therefore, who made that law, they were not aware of the fundamental rights in the first place. So therefore, it is not their mistake to make such a law. But whereas in case of a post-constitutional law, it was a first place, it was a mistake to make that law in that way, because it is in violation of the fundamental right. That is why different doctrines apply. So anyways, this is not related to the center state relationship, it is only related to the fundamental laws in violation of the fundamental rights. Rarest of rare doctrine is related to the center state relationship. It has nothing to do with the center state relationship. It is only, this doctrine is applied in awarding what is called as capital punishment by the Supreme Court. This was also in the newspaper for some reasons. So before giving capital punishment to any individual in a case, the Supreme Court has said that the court should be convinced of this particular doctrine, that is rarest of rare doctrine. That is only in the rarest of rare cases, the individual should be given the capital punishment, by taking into account both the aggravating as well as the mitigating factors. So what is an aggravating and the mitigating factors? Very quickly, I am not going very deep into this. Aggravating and mitigating factors should be taken into account. So the rarest of rare doctrine always wanted the judges to look into the facts of that particular case. What are aggravating and mitigating factors? Mitigating factors will help the judge to reduce the punishment. So for example, his state of mind at that point of time, the threat that was there before he was committing that particular offence, what was the pain that was inflicted by the other party when he committed that particular offence, because out of fear somebody does a murder. So it is a mitigating factor. Aggravating factors are those factors how he has actually done that particular offence, who was affected because of that particular offence committed against a woman, offence committed against a children. So these are all aggravating factors. Okay, so we'll have to see what is a mitigating and aggravating factor. So anyways, is not related to center state relationship. What about doctrine of pith and substance? Yes, doctrine of pith and substance is related very much to what is called as the center state relationship. So what is this doctrine of pith and substance? It is a doctrine that was innovated by the Supreme Court to resolve any dispute between two legislatures. That is, if the parliament and the state legislature come before the Supreme Court that one legislative body is trying to encroach the legislative authority of another body, then the Supreme Court will use this particular doctrine to resolve this particular dispute. So therefore, it is directly related to what is called as center state relationship. So this is true, but can anyone explain me what is this doctrine of pith and substance? Pith means the essence of this particular law, essence, or what is the objective of this particular law, or what is the objective based on which this particular law is made, and substance means what is the subject matter on which, or what is the item on which the law is made. What is the subject matter or the item on which the law is made? On top of that, the essence is more important. What is the objective for which this particular law is made? So applying this particular doctrine, the Supreme Court can come to a conclusion whether the law is a valid law or an invalid law. For example, in 1950s, a law was made by State of Bombay to prohibit the sale and consumption of alcohol, and the prohibition of sale and consumption of alcohol was an item in the state list. But the center challenged this particular law because this law also had some impact on the import and export of goods, but import and export is an item in the central list. So therefore, this law was challenged by the center. So then the Supreme Court applied the doctrine of pith and substance. So then first they looked into the subject matter. The subject matter is directly related to whom? It is related to the state. And then they also looked into the objective. The objective of the state to make this particular law is not to create any problem with regard to import and exports, but their objective was only to prohibit the sale and consumption of alcohol. But even then it had an unintentional encroachment upon the powers of the center, that is an incidental encroachment upon the powers of the center. So by applying this particular doctrine, if the Supreme Court is convinced, if a law is on a particular subject matter and the objective is to only to regulate whatever is the subject matter which is under a particular legislature, but even in this case, if it is an unintentional encroachment upon an item in the other list, still the law would be considered to be a valid law. Okay, so this is basically what is called as doctrine of pith and substance. So in this case, the law made by the State of Bombay was considered to be valid. Okay. So what is the answer here? It is 3 only. As per the constitution, 2 or more states can request the parliament to make a law on the state list by passing a resolution in the concerned state legislature by, what is the majority with which they have to pass a resolution? Simple majority. They have to pass a resolution by simple majority. Here it is only simple majority. Is it possible for the other states to adopt this law? And they have to pass a resolution again by a simple majority. So they don't even have to send it to the parliament. They have to just pass a resolution and they can adopt this law. But once the law is adopted, in the future, the law will apply in those states as well. And who will have the power to amend this law? It is only the power of the parliament henceforth. Which article in the Constitution of India empowers the parliament to make laws relating to interstate river water disputes? Article 262 of the Constitution. Which of the following is true regarding the granting aids from the center to the states allowed under Article 275 of the Constitution? Which of the following is true? They are statutory grants. What does it mean by statutory grants? It requires a law based on which it can be done. So under Article 275 of the Constitution, while the granting aids can be given to the states from the center, which is apart from whatever is the allocation that is given. So for example, based on the 15th Finance Commission, how much amount of revenue of the center should go to the states, 41% of the divisible pool of revenue, not the entire taxation, because certain tax exclusively goes only to the center. Say for example, cess, surcharge, these are all exclusively only to the center. But apart from that, there are certain taxes which is collected by the center comes under the divisible pool. So in the divisible pool, among the divisible pool, the 15th Finance Commission said 41% revenue shall go to the states, but that is a vertical distribution. Again, this 41% will be horizontally distributed among different states based on the recommendation of the Finance Commission. Now, if you see, apart from this, if the center wanted to give some grantee aids to specific states, not to all the states, they can give. Under which article they can give it? Under Article 275 of the Constitution. But this is only a statutory grant, which means it requires a law before a grant is given to that particular state. And this is also done on the basis of what is called as the recommendation that is given by the Finance Commission. Okay, so whenever the money is given to the states, it has to come from the Consolidated Fund of India. So when the money is coming from the Consolidated Fund of India, either it has to be a made expenditure or a charge expenditure. So therefore, the next question is whether the grantee aids that is given to the states under Article 275 of the Constitution, is it a made expenditure or a charge expenditure? Made or charged? It is a charged expenditure and not a made expenditure. So therefore, what is the first statement? The first statement, it is a statutory grant, it is a charge expenditure, it is not a made expenditure. So what is the answer here? 1 and 2 only. So what is the difference between a made and a charge expenditure? The AC is, I think, is on the little higher side, no? So what is the answer? It is 1 and 2 only. Yes, what happened? So sometimes it happens like that. So you have to persist for some time before the luck can favor you. So this happens when we travel also. We go to one toll booth, suddenly we change other place, then that stops. So it is better to wait for some time before taking a decision. Okay. Okay. Which of the following are the functions of? Okay, come to the next thing. Which of the following are the functions of the GST Council? Now tell me, what is the position of this GST Council? It's a constitutional body. It is directly established under which article? 279. Very good. 279A of the Constitution. So just try to remember this article 279A, and it is having a constitutional status. So what is this GST Council, as far as you know? What is the purpose for which this GST Council is established? Now today this GST Council is apex body to take all decisions regarding GST in our country. Any dispute arising between the center and the state, that will also be heard by the GST Council. And the GST Council has representation from both center as well as the states. Who heads the GST Council? Union Finance Minister. And there is also representation from the states. Either the Finance Minister of the state or his deputy, that is the Minister of State, can represent the states. And they have all the powers to decide with regard to different tax rates for different goods and services in our country. What are the goods and services that may be exempted? So these are all some of the things that is decided by what is called as GST Council. You try to have a broader idea at least. So just come to this particular question. Which of the following are the functions of the GST Council? Determining the tax rates under the goods and services tax. Yes, so they will determine for the various goods and services what shall be the tax rates. Goods and services that are exempted from the GST regime, they are the authority to decide that also. Suggesting measures for periodic reforms relating to the direct tax code. They have nothing to do with the direct taxation, because GST is an indirect tax reform. So therefore, they have nothing to do with the direct tax. Okay, so this is definitely wrong. This is not part of their functions. Does any know what constitutes? As per the Constitution, the GST Council can function only when there is a quorum. Without quorum, the GST Council cannot function. Does anyone know what constitutes quorum in GST Council? Not less than half of the members, not less than 3/4 of the members, yes, 3/4 of the members, not less than 1/10 of the members, not less than 1/5 of the members. Okay, so the answer is not less than half of the members. 50% of the members constitute quorum in the GST Council. 3/4 is not the right answer. 3/4 is to arrive at any decision. So the number of value of votes that has to support is minimum value should be 3/4. So that is the value that they have to arrive at any decision, of which again 1/3 weightage is given to the center and 2/3 weightage is given to the states. How that is calculated, you don't have to worry, but just remember all these factual information. So what is the answer in this case? It is 1 and 2 only. Come to the next question. Okay, this is part of your current affairs. Very, very important question. I feel that at any time they can ask you from this area. The term general consent recently reported in the newspaper is related to. So the term general consent is related to what? CBI. How many of you think it is related to CBI? It is related to the CBI. So the CBI today in our country, is it a constitutional body, statutory body, body established by an executive order or an executive body? How many of you think it is an executive body? Anybody who thinks it's a statutory body or a constitutional body? Anybody who thinks it's a statutory body? CBI is not a statutory body, not a constitutional body. The CBI is only an executive body. You will have to see how the body is established. How the body is established? CBI is established only by a resolution that was passed by the Home Ministry. Initially when it was established in 1960s, I think 1963 to be very specific. Now today CBI is under the administrative control of which ministry? Today it is not under the Home Ministry, today it is under the Department of Personnel and Training. It is the Department of Personnel, Pensions and Public Grievances. To be very specific, under the Department of Personnel and Training. So even today it continues to be what is called as an executive body, but this body continued to derive its power from the Delhi Special Police Establishment Act. So do not think it is a statutory body, because if it is a statutory body, it has to be established by a statute. But CBI was not established by a statute, it was established by a resolution passed by the Union Cabinet and kept under Home Ministry initially, today under Department of Personnel and Training. But this body continued to derive its power from the Delhi Special Police Establishment Act, passed in 1946, DPSC, DS, Delhi Special Police Establishment Act, 1946. So if you look into this act, when it was established, the CBI today continued to derive this power from this particular body. So as per this particular act, CBI today can investigate into the cases only within the territory of National Capital Territory of Delhi. But if the CBI is to investigate on any cases outside the National Capital Territory of Delhi, then in that particular case they have to take the consent of the states. But however, to enable the process easier, to make the procedure so easy, it would be very difficult for CBI to take the permission of the states for each and every case which they want to investigate beyond this particular territory. Therefore, there is a provision in Delhi Special Police Establishment Act, which is also called as Section 6 of the Delhi Special Police Establishment Act, which allows the states to give what is called as general consent. If the states give general consent to the CBI, this general consent is usually valid for 6 months. That means for the 6 months, the CBI does not have to take a permission case to case basis. So at the end of 6 months, an automatic approval is again given. So therefore, the CBI can go directly and investigate the cases in the other states beyond the National Capital Territory of Delhi. But of late, you can understand that there is a lot of problem that is happening between the center and various states. And various state governments are accusing the center that the CBI is being misused, or it is used as a political tool to corner the opposition parties. So many states have withdrawn the general consent. And recently it was in news because the state of Karnataka has withdrawn the general consent, because the center has used the CBI against the Chief Minister of Karnataka also. We are not sure whether the allegation is true or not, let us not get into that, but anyways, here it is part of your current affairs. So therefore, the state of Karnataka has withdrawn the general consent, and many states, not only state of Karnataka, I think Punjab has withdrawn it, West Bengal has withdrawn it, Tamil Nadu has withdrawn it, Telangana has withdrawn it, now Karnataka has also withdrawn it, some of the northeastern states have also withdrawn it. So this is what is related to the general consent. But however this matter then subsequently, because this is a long standing issue, so the matter was taken by the CBI to the Supreme Court of India also. So the Supreme Court of India has said that while the general consent is required, and if the general consent is not there, if the CBI is to investigate in the territory of the states, then they have to take the permission of the states on a case to case basis. But the states cannot prevent the CBI from investigating cases related to the central government employees, even if it is outside the territory of the Delhi. Central government employees, and if any matter is referred to the Supreme Court by the High Court and the Supreme Court, because as per the Supreme Court directions, High Court can also refer certain matters to the CBI. The Supreme Court can also refer certain matter to the CBI. So wherever the matters are referred by the Supreme Court and High Court directly to the CBI to investigate, there even if they have to investigate outside Delhi, there they don't have to take the permission of the states. Is that clear? So these things you please keep it in your mind. So anyways, what is the answer in this particular case? The term general consent recently reported in news is related to what? States approval to the center to allow CBI to investigate in the states without requiring case specific approval. So if the general consent is not there, then also they can investigate, but for every case they have to specifically take the approval. Yes. It's okay, CBI is under the control of whom? Center, so that is why it is center. Okay, CBI is directly under the charge of Department and Personnel and Training, and which is the part of the central government. Suppose if it is a constitutional body, I would not use the word central government, but it is just an executive body which is under the control of the center. So the general consent, normally there is a clause that it is an automatic approval. So normally it is a formality, but the states have to give the approval. Then at any time the states can withdraw it. It is not that definitely they have to give the approval. Okay, so the states have the power to withdraw it. Okay. Okay, come to question number 333. Consider the following statements. The GST Council was established. GST Council was established by the 101st Constitutional Amendment Act 2016. Is it true? Yes. This we have seen. The council has representatives from both union and the state executives. Yes. 1/10 of the members of the GST Council constitutes quorum. It is not 1/10, it is only half. Half of the members of the GST Council. Okay, so constitutes what is called as quorum in the meeting. So what is the answer here? 1 and 2 only. Which of the following amendments transferred significant number of items from the state list to the concurrent list? 42nd Constitutional Amendment Act, which has transferred 5 items from the union list to the, from the state list to the concurrent list. Article 226 of the Constitution of India allows for the establishment of what? Consolidated fund of India and the states, and it also allows for what is called as the public accounts of India and of the states, and not the contingency fund of India and the states. Contingency fund of India is established under which article? It is not established under Article 267. Article 267 is only giving the power to the Parliament, and then therefore the Parliament can make a law and they can establish it. But yes, you can see the genesis of the contingency fund from Article 267, but not directly under Article 267. So what is the answer here? 1 and 2 only. Alright. So with that we are done with the center state relationship as well. So very important, you can expect one question. Majorly if you see the center state relationship, the questions are revolving around those 5 articles that I discussed most of the times. Article 249, Article 250, Article 252, 53 and Article 356, okay. And sometimes they can ask from this Article 355, 256, 257. So try to cover all these things, okay. So remember all these things. So come to the local bodies, again one question from this particular area. Very simple questions are usually asked from the local bodies. We will try to quickly touch upon that also. Which one of the following authorities make recommendations to the governor of a state as to the principles for determining the taxes and duties which may be appropriated by the Panchayat in a particular state? Who will do that? The State Finance Commission. It is a State Finance Commission who will make the recommendation, not any of these things. Okay, the State Finance Commission will make the recommendation. Who appoints the State Finance Commission? Who appoints the chairman and the members of the State Finance Commission? The governor of that particular state. But what about the qualification of the members of the State Finance Commission? Who will decide that? Is it mentioned in the constitution? What about the composition? Is it mentioned in the constitution? The composition is not mentioned for the State Finance Commission. And their qualification, is it mentioned in the constitution? Is not mentioned. So it is not mentioned, then who is going to decide it? Both the composition as well as their qualification are to be determined by the law made by the concerned state legislature. So that is very, very important. But however, how is it different from the Union Finance Commission? In Union Finance Commission, who appoints the chairman and the members of Union Finance Commission? It is the president who does that. Clear? Okay, president does it. But what about the qualification and the composition of these members? Composition is directly given in the constitution, but what about the qualification? Qualification is based on the law that is made by the parliament. Okay, so this is the answer. Come to the next question. If a panchayat is dissolved, the elections has to be held. That is what, within what time the elections has to be held to that panchayat? 6 months. What is the maximum time? It is 6 months. But if the panchayat is prematurely dissolved, let us assume, where the remainder of the time is less than 6 months, in that case there is no need to conduct the panchayat because anyways elections are coming. But if the remainder of the term is more than 6 months, then definitely they have to conduct the election within what is called as 6 months. So the answer is here. And one more question is, what if a panchayat is prematurely dissolved? If the panchayat is prematurely dissolved, the new panchayat that is constituted will be for a full 5-year term, or it is only for the remainder of the term? It is only for the remainder of the term. Is it clear? The 73rd Constitutional Amendment Act refers to. So can you give me the answer for this question? The 73rd Constitutional Amendment Act, it is not related to any generation of employment. So definitely that is not the answer. Generation of employment to able-bodied adults, no. Laying foundation for strong and vibrant Panchayati Raj institutions in the country. Is it true? Okay, can you tell me which of the committees have recommended for the constitutional status? If you see the Lakshmikant book, they are given about some of the committees. They are not very important. Maybe you can just read it once, not more than that. So no question is likely to come from that particular area. Except one area, they can ask you which of the committees have recommended the constitutional status to Panchayati Raj. So which of the committees have given constitutional status? LM Singhvi has given, Ashok Mehta committee has given, Balwant Roy has not given the constitutional status. LM Singhvi has given the constitutional status. I think there is one more committee, PK Tungan committee. So that has also given the constitutional status. So just go and refer it once, which of the committees has given the constitutional status. But anyways, I don't think UPSC will focus on that. because UPSC is only going to focus on the constitution, not from the other areas, but in case just to be on the other side. So, just to see which of the committees, I think 4 committees there which has given the constitutional status. What is the last committee? No, after Tangan committee there was one more committee, GVK Rao committee. I think GVK Rao committee has also recommended constitutional status. So, all these 4 committees have recommended the constitutional status. Okay. So, what is the answer? Sorry, the answer is C. Guarantee life and liberty. So, this is not related, this is not related, not related. Which one of the following is not a provision of the 73rd Constitutional Amendment Act in the area of Panchayati Raj? 33% seats to all the elected rural bodies will be reserved for women candidates at all levels. It is there? Yes. It is there at all the levels for the women, including at the Panchayat, including all the levels, okay, but the village level, at the intermediate as well as at the district level. The states will constitute their finance commission to allocate resources to the Panchayati Raj institution. It is also a provision, yes. The Panchayati Raj elected functionaries will be disqualified to hold their offices if they have more than 2 children. This is not there in the constitution. The constitution does not provide for it, okay. Some of the states wanted to bring in such legislation. They should have some education, functional toilet, number of child, but that is strict, that is not in the constitution of India. The elections will be held in 6 months in time if the Panchayat bodies are suspended or dissolved by the state government. Is it true? Yes. So, therefore, what is the answer here? It is C, which is the answer. Come to the next question. What is the system of governance in the Panchayati Raj setup? What is the system right now? Single tier structure of local government at village level, 2 tier system of local governance at the village and block levels, 3 tier structure of self government at village, block and the district level. Yes. So, this is a system that you have got. So, before the 73rd Constitutional Amendment Act, the structure was not uniform, and one thing that was done by the 73rd Constitutional Amendment Act is it has brought in uniformity with regard to the structure. Who can be called as a father of local government in India? It was Lord Ripon. So, way back, even before India became independent, he has brought in lot of changes both with regard to Panchayat and municipalities. So, most of the system that we follow today, except for uniformity in structure, was already put in place, and who has been very influential in all those things? It was Lord Ripon, especially in the area of municipalities. The right answer is Lord Ripon. Consider the following statements with regard to the Panchayat system in India. Statement 1. Presently, the Panchayat election to all the states has to happen at the same time to ensure uniformity. Is it true? Presently, the Panchayat election to all the states has to happen uniformly. Is it true? Not necessarily. For this, it is not that for all the states it has to happen uniformly. Within a state, it has to happen at the same time. Okay. Because even after the 73rd and 74th Constitutional Amendment Act, there was certain time limit for the states to establish the Panchayat system. It is not done at the same time. Therefore, there is no need to have it uniformly. So, that is definitely not the requirement. All state governments should transfer minimum fixed amount of their taxes to the Panchayat as provided in the constitution. Is it true? Giving finances, devolving finances from the states to the Panchayat is a prerogative of the states, which will be determined by the law that is passed by the concerned state legislature. One of the major concern is that devolution of finances is a prerogative of the state. So, therefore, this is also wrong. The reservation of seats in Panchayat to the other backward caste is mandatory in proportion to the population as per the constitution. It is not mandatory, it is only a voluntary provision. Only some of the states have given reservation to the other backward caste. I think Maharashtra is one such state which has brought in reservation to the other backward caste. Most of the states in India has not given any reservation to the other backward caste in Panchayats, because it is not a mandatory provision, it is only a voluntary provision. So, for women it is mandatory, for the scheduled caste and scheduled tribe also it is mandatory but not given specifically in the constitution. It is only saying by a law in proportion to the population they can give it. So, which of the statements given above are correct? So, none of the above is correct. For the scheduled caste, in case of members it is mandatory, in case of chairpersons by a way of a law that is made by the concerned state legislature. Which of the following is the objective of giving constitutional status to the Panchayat and municipalities under the 73rd and 74th Constitutional Amendment Act? Among the thing, so which of the following are the objective? To ensure direct democracy. How many of you think to ensure direct democracy? It is not the direct democracy. The objective is not to provide what is called as direct democracy. What is direct democracy? The people get to decide and do everything, but in the Panchayat also it is not the people who will get to decide and do everything. Who will do the things? It is only the elected representatives. Don't confuse Panchayat with Gram Sabha. Gram Sabha is just one aspect of the Panchayati Raj system, and in fact the Gram Sabha is not given any direct powers under the constitution. The constitution only says that there should be a Gram Sabha at the village Panchayat, and that too Gram Sabha is not there at the other levels of Panchayat. So therefore, the idea of Panchayat is not to bring in direct democracy. The very important objective of the Panchayat is to bring in what is called as people's participation in the system of governance. Do people participate in the system of governance? Because it is the elected representatives who have to take care of certain functions at the Panchayat level. So therefore, the people's participation is there. To ensure accountability, of course it will ensure accountability. See, in UPSC there was one question which is talking about political accountability. So political accountability is different from what is called as mere accountability. Accountability means that they can just go and question. So of course it will ensure a system of what is called as accountability. So it has to be seen for each and every question. So yes, it is going to ensure accountability, because of course the local representatives who are elected may be questioned by the local people if they are not doing the job. So therefore it ensures accountability. To implement universal adult suffrage, universal adult suffrage was already there even before the 73rd Constitutional Amendment Act was brought into place, before it was given a constitutional status. So therefore, what is the right answer in this particular case? It is, okay, so the option, I think based on the options you were confused. Okay, so, so the right answer is only 2 and 3. I will just make it 2, 1. Okay, so this, let it be 1 and 2. I will make a correction here, 2 and 3. So what is the option here? It is option C. Have you made note of certain corrections that you are making? Because when you revise it, you should not get confused. The state election commissioners can be removed by whom? The state election commissioner can be removed only by the President of India. Though the state election commissioner is appointed by the governor, the state election commissioner can be removed in the same manner as that of a judge of a high court. And how a judge of high court is removed? The judge of high court is removed in the same manner as that of a judge of a Supreme Court. So in both the cases, the motion has to be passed in the parliament and then subsequently approved by the President of India. So who is authority to remove the state election commissioner? It is the President of India. Consider the following statement. Statement 1. The minimum age prescribed for any person to be a member of Panchayat is 25 years. What is the minimum age? 21 years, not less than 21 years. So therefore, this particular statement is wrong. The Panchayat constituted after the premature dissolution continues only for the remainder of the term. Is it true? Yes, it is true. Which of the following is our mandatory provisions under the 73rd and 74th Constitutional Amendment Act? So this is very, very important. You should have an understanding of what is mandatory and what is voluntary. Can you solve and give the answer? Then I will discuss about it. What is the answer? Which of the following is, I will complete 350 questions and then I will take some doubts from the online students. Which of the following are mandatory provision under the 73rd and 74th Constitutional Amendment Act? Regular elections, is it mandatory? Yes, every 5 years there should be election to the Panchayat and the municipalities. This is there. Reservation for OBCs in the local bodies, that is a voluntary provision. Reservation to women in local bodies, yes, that's a mandatory provision. Devolution of powers and finances, both giving powers and finances, they are not mandatory provision, it is only a voluntary provision. Based on what? Based on the law that is passed by the concerned state legislature. So, the law made by the state legislature will decide this. So, therefore, you will have to make it very clear in your mind that the Panchayat in different states in our country might have different functions and they may exercise access to different amount of finances. But who is going to decide all those things? The law made by the concerned state legislature. Okay, so there is no uniformity in this regard. So, what is the answer here? It is 1 and 3 only. The local government in India can be best explained as an exercise in what? The best way that it will explain is it democratic decentralization. There's just we are bringing one more step of what is called as decentralization, democratic decentralization. Again, not direct democracy. Direct democracy means ruled by people directly. So, in the local democracy, in the local government also, it is not the people themselves get to decide everything. It is only an exercise of democratic decentralization. That means we are constitutionally recognizing the local bodies. The 73rd Amendment Act 1992, the Constitutional 73rd Amendment Act 1992, which aims at promoting the Panchayati Raj institutions in the country, provides for which of the following? Constitution of district planning committees. Is there constitution of district planning committees? So it is there in the 70, yes, it is in the 74th Constitutional Amendment Act. State Election Commission to conduct the Panchayat elections, yes. Establishment of State Finance Commission, yes. So what is the answer? 2 and 3 only. So option C is the right answer. So how many of you are confused with this district planning committee? So you have to be very careful, okay. It was there in the 74th Constitutional Amendment Act. Who shall constitute the State Finance Commission as per the Constitution? The governor of the particular state. Consider the following statements. 1. The conditions of service of the state election commissioner shall not be varied to his disadvantage during the term of office. Yes, it shall not be varied. This protection is given in the Constitution itself. The governor of the state shall make necessary staffs available for the state election commission to carry out the election to the local bodies. Is it true? Yes, it is a governor who has to make the necessary staffs available to carry out the election to the local bodies, which is there under the Constitution. For carrying out the election to the Lok Sabha and to the state legislative assemblies, who has to make the necessary staffs available? To the Election Commission of India, the president and the governors both have to make it. So, the central government employees will be deputed by the president of India to the Election Commission and the state government employees will be done by the governor. But when it comes to the local bodies, the governor has to make the necessary staff available. The state legislature is free to make laws relating to the election of the local bodies subject to the provisions in the Constitution. Is it true? Who will make laws as to how the local body election is to be carried out? State legislature, of course, and it is subject to the provisions in the Constitution. The state legislature cannot make a law and say that the state election commission will carry out the election every 10 years. That is not possible because the Constitution says the election has to happen every 5 years. So, it is subject to the provisions in the Constitution. Who will make the law? The state legislature will make the law. So, therefore, how the local body election happens in our country might vary from state to state depending upon the law made by whom? Depending upon the law made by the concerned state legislature. Is that clear to all of you? So, the answer here, what is the statement here? So, this is true. So, what is the answer? It is option C. Okay, I'll just take a couple of minutes. There are some questions from the online students, and if you have any doubt, you can also ask me. Let me just take a couple of minutes. Sir, can you please explain the collegium system for the transfer of High Court judges? So, what constitutes the collegium for the transfer of High Court judges? It is Chief Justice of India plus 4 senior most judges. So, they are the collegium and they will recommend the President of India with regard to the transfer of judges. But this collegium, that is Chief Justice of India plus 4 senior most judges, this collegium, before recommending for the transfer of the judges of the High Court, they in turn have to make a written, they in turn have to consult and take a written recommendation of the Chief Justice of the both the High Courts. So, for example, in the recent current affairs, a judge was transferred from the Delhi High Court to Uttar Pradesh High Court. So, therefore, the collegium, before making the recommendation, they have to take the written recommendation of Chief Justice of Delhi High Court and the Chief Justice of Uttar Pradesh High Court, and then they can make the recommendation to the President of India. Okay, so there is one more question. Sir, in the Shreya single case, the doctrine of eclipse, only a portion of the law will be struck. The Shreya single case, if you remember, it was challenged on the grounds of what? That the Information Technology Act, section 66A of the Information Technology Act was violative of the right to freedom of speech and expression. So, the Information Technology Act, that is section, to be very specific, section 66A of the Information Technology Act, is it a pre-constitutional law or a post-constitutional law? Post-constitutional law. So, therefore, the doctrine of eclipse will apply or the doctrine of severability will apply? Doctrine of severability. So, therefore, the portion, that particular portion of section 66A was struck down from the law. Is that clear? There is no doctrine of eclipse in case of Shreya single case. Okay, whenever I say it is appointed by the governor, the State Finance Commission is appointed by the governor is an appointing authority. It does not mean that the governor has a discretionary power. The governor acts on the aid and advice of the Council of Ministers. What is question number 339? Any doubt in question 339? %33% of the seats is reserved for the women, so that is given in the constitution. Okay, 30 is given. So then will you arrive at any of the right answer? Panchayati Raj elected functionaries will be qualified to hold their offices if they, oh, so it is there. It should be 33, I think some mistake is there. It should be 33%. So just make a small correction. Option C is very abrupt. So therefore that is the right thing. Some mistake is there. That is 33%. It is not 30%, it is 33%. What is the question? 339. In option A, it is given 30%, so it should be 33%. Again, if the Rajya Sabha passes a resolution, the Parliament just cannot make a law. Again, a resolution has to be passed by the Rajya Sabha in national interest. And whenever the resolution will be passed by the Rajya Sabha, then that resolution will be in force for 1 year. And within the period of 1 year, a law has to be made by the Parliament. And that law will be again in force only for a period of 6 months after the resolution ceases to exist. That is in case of appointment of judges of High Court. Only for the appointment of judges of High Court, that is the collegium. Okay, so I think we are done with the local bodies also. So this is the question, just to attempt one question from this particular area. So now come to the next topic, that is emergency provision. Every year there is a question on emergency provisions as well. Very, very important. Shall I move to the emergency provisions? Yes. Okay, shall I move? Okay, so come to the question, next question, that is article 351. So we'll have to complete at least up to 400 questions. So please cooperate. Okay. I'll have to, I think, leave 5 minutes early. Today also you have a class? Okay. So I'll try to leave a little early. So come to question number 351. Consider the following statement in respect of the financial emergency under Article 360 of the Indian Constitution. With regard to financial emergency, few things that you have to remember. Who can declare the financial emergency? The President on the recommendation of the Parliament, on the recommendation of the Council of Ministers. But this financial emergency, once approved by the President, is not final. It has to be placed for the approval of the Parliament. Both the houses of the Parliament has to give the approval within a period of 2 months. And once it is approved, it can continue indefinitely. There is no need for any further approval by the Parliament. Once approved, it continues indefinitely till the time it is revoked by the President of India. And the President can revoke it at any time, again based on the aid and advice of the Council of Ministers. But whenever the financial emergency is imposed, there can be few consequences. What are the consequences? That the President can tell the states to how they have to spend their money. The President can give direction to reserve all the financial bills for the consideration of the President. The Union government can reduce the salaries and allowances of all classes of central government employees, including the judges of the Supreme Court. So similarly, the state government can also reduce the salaries and allowances of the state government employees, including the judges of the High Court. So these are all the possible consequences. And under what condition the financial emergency can be imposed is when the credit and the stability, financial credit and the stability of India is threatened, but we have no precedent for what is called as a financial emergency. So quickly come to the question. The proclamation of financial emergency issued shall cease to operate at the expiration of 2 months unless before the expiration of that period it has been approved by a resolution of both houses of Parliament. Is it true? It is true. It has to be approved by both houses of the Parliament, and it has to be approved within a period of 2 months. So this particular statement is true. Come to statement 2. If any proclamation of financial emergency is in operation, it is competent for the President of India to issue directions for the reduction of salaries and allowances of all or any classes of persons serving in connection with the affairs of the Union, but excluding the judges of the Supreme Court and High Court, including the judges of the Supreme Court and High Court. So this is definitely false because nobody is excluded here. Okay, so this was wrong. So what is the answer here? 1 only. Come to the next thing. The term of Lok Sabha cannot be extended under any circumstances, can be extended by 6 months at a time, can be extended 1 year at a time during the proclamation of national emergency. Yes, it can be extended 1 year at a time, but how long it can be extended? Indefinitely. And who is authority to extend? The Parliament by a law, they can extend it. Very good. So the answer is can be extended. Consider the following statements regarding the consequences that may arise as a result of proclamation of national emergency by the President of India. Under which article the President can proclaim national emergency? Article 352. And the President can do so how? Can he do it on his own? Only on the written recommendation of the Cabinet. That is very, very important. The written recommendation of the Cabinet. The only article where the word Cabinet is mentioned is Article 352 of the Constitution. The Parliament is empowered to make laws on all the items including the state list in the 7th schedule of the Constitution. Is it true? Yes, they can make laws on all the items in the state list. Nothing prevents the Parliament to do so. Okay. But however, this law is a temporary law. We have already seen that. But that is not the question here. But remember that. The President is empowered to suspend the enforcement of fundamental right, including Article 21 of the Constitution. Is it true? Presently, it is not possible. Okay. Before 1978 it was possible, but assuming that it is a present situation, it is not possible. Now, in this extent, you will have to understand very quickly about Article 358 and Article 359 of the Constitution, because suspension of fundamental rights is related to both the things. So, can anyone tell me what is the difference between Article 358 and Article 359? Here, the first important thing is there is an automatic suspension. Automatic suspension of fundamental rights, that is what is very important. Suspension of fundamental rights. When you say automatic suspension of fundamental rights, that whenever the national emergency is there, automatically the fundamental rights stand suspended. Fundamental rights stand suspended means the right does not exist in the first place. And what fundamental right can be suspended? Only Article 19. It's only Article 19 which can be suspended. So automatic suspension, that means Article 19 does not exist. It means as if there is no Article 19 in the Constitution during the time of emergency. And this can happen only in case of what? For external reasons. If the emergency is for external reasons. What are the external reasons? It is because of what is called as war or external aggression. Okay, so these are the things. But here there is no automatic, it is only done by a presidential order. A presidential order is required provided there is a national emergency. After the national emergency, a presidential order is required, and to the presidential order the president can specify the fundamental rights what he is going to suspend, but not the fundamental right is suspended per se, the enforcement of the fundamental rights is suspended. So here he can do so by a presidential order, except which articles? Except 20 and 21. And which constitutional amendment act made this particular change? The 44th Constitutional Amendment Act 1978. All the changes related to the emergency is 44th Constitutional Amendment Act, because the Janata Party came, they made all the changes after the emergency. So except 20 and 21, any of the other fundamental right, their enforcement can be suspended. What does it mean by their enforcement can be suspended? That means the article continues to exist. I said here it is assumed that the article does not exist, but here the right is there, but Article 32 stands suspended in relation to these articles. That means this right is there, but what is Article 32 of the Constitution? Article 32 gives us a constitutional remedy. When our right is violated, we can go to the court. But Article 32 in relation to these articles, which is issued by the presidential order, stands suspended. Therefore, we will not be able to go to the court and get it enforced. But after the emergency is over, we can go to the court and get it enforced. Okay, and here it can be for any reason. So it can be for any reason. When I say it can be an external reason or an internal reason, it does not matter. Okay, so that's basically what you'll have to understand. Now with that, just come to this question. The president is empowered to suspend the enforcement of any of the fundamental rights, including Article 21 of the Constitution. No, Article 20 and Article 21 is not possible. The union government can unilaterally alter the distribution of revenue between the center and the state. Is it possible during national emergency? Of course, yes. Don't confuse this with a financial emergency. During national emergency, the union government can unilaterally alter the distribution of revenue between the center and the states. So normally, what is the distribution of revenue between the center and the states is based on the recommendation of the Finance Commission. But during national emergency, the union government has nothing to listen to what the Finance Commission says, and they can unilaterally distribute the revenue between the center and the states. But if at all they disturb this distribution of revenue between the center and the states, how long they can unilaterally change the distribution of revenue between the center and the states? It can continue till the maximum time of the end of the financial year in which the emergency is revoked. In whichever financial year the emergency is revoked, even after the emergency is over, the altered distribution of revenue can continue till the end of that particular financial year. Okay, so that is what is given in the Constitution. But here, can the union government unilaterally alter the distribution of revenue? Yes, so this is true. So what is the answer here? 1 and 3 only. Come to the next question. Which of the following are the immediate consequences of the imposition of president rule in a state? Immediate consequences. Whenever you have any doubt, come to the options, and that is how you should do in the UPSC also. Don't just jump into conclusion. Don't put right in here and then check this. Any doubt, come here. From here you go there. Okay. So whenever you know something is completely wrong, then just eliminate those options. From the question, from the options you go to the question. Which of the following are the immediate consequences of imposition of the president rule? What will immediately happen after the president rule is imposed? Dismissal of the Council of Ministers. So this is definitely there. So there is no doubt in this regard. And then the dissolution of the local bodies in the state. The president rule has nothing to do with the local bodies. It has only to do with what is called as a state government. Okay. So this is definitely not the answer. Suspension of fundamental rights. President rule has nothing to do with fundamental rights. Financial emergency has nothing to do with fundamental rights. The only emergency is the national emergency. So anyways 3 and 4 is not there. So 4 you eliminate. So 3 also you eliminate. Okay. So what we are left with? 1 only and none of the above. So dissolution of legislative assembly, this will happen, but it is not an immediate consequence, because immediately it will be kept only under suspended animation. But once the parliament gives the approval, so whenever a president rule is imposed in a particular state, that is not a final thing, then it is placed for the approval of the parliament. Within how much time the parliament has to give the approval? Within a period of 2 months the parliament has to give the approval, and once the parliament gives the approval, then only the legislative assembly can be dissolved. So till the time it is kept under only what is called as suspended animation. Now what is the majority with which the parliament has to give the approval? What is the majority the both houses of the parliament has to give the approval? It has to give the approval with simple majority. For national emergency is the only case where there is a need for a special majority. But whereas in case of president rule as well as in case of financial emergency, the majority that is required is simple majority. So what is the answer? 1 only. The national emergency under the Constitution of India can be extended how long? How long the national emergency can be extended? Indefinitely, provided the parliament makes a law every year and extend it by 1 year at a time. Okay, sorry, the national emergency, I am not talking about the Lok Sabha. The national emergency can be extended indefinitely provided the parliament gives the approval every 6 months. Okay, so every 6 months they have to give the approval. And what is the majority with which they have to give the approval? Here it is the special majority. What was the provision in the original constitution? In fact, this provision was brought in only by the 44th Constitutional Amendment Act in 1978. What was the provision in the original constitution with regard to this? Once it is approved by both houses of the parliament within a period of 2 months, now it is 1 month, within a period of 2 months in the original constitution, then it continues indefinitely till it is revoked by the president. Okay. So there in the original constitution it can be revoked only by the president, but presently if the national emergency is brought to an end, what are the ways by which it can be brought to an end? It can be revoked by the president on the advice of the Council of Ministers. Alternatively, if the Lok Sabha passes a resolution, that is also binding upon the president. And what is the majority with which the Lok Sabha has to pass a resolution? Simple majority. If the President of India exercises power under Article 356 of the Constitution in respect of a particular state, then the Assembly of the state is automatically dissolved. The Assembly does not get automatically dissolved because it has to be approved by the Parliament, so there are some procedures. The power of the legislature of the state shall be exercisable by or under the authority of the Parliament. Is it true? So whenever we have seen that in a state a president rule is imposed, once the legislative assembly is dissolved, then who will take up the power? Even otherwise also, even if it is not dissolved also, the assembly will be kept under suspended animation. So who will take up the power to make laws? Parliament. And the parliament can delegate this power to other authorities as well, including the president, but it does not directly go to the president. It is only the parliament who has got the power from the constitution. Article 19 stands suspended. No relation. The president can make laws relating to that. That does not happen automatically, provided the parliament gives the power. But who takes the power? It is only the parliament which has got the power. So what is the answer? Option B. Consider the following statements. During the state emergency, the fundamental rights can be suspended, while it cannot be suspended in case of national emergency. Rather, it is vice versa. So therefore, this particular statement is wrong. The state emergency can be extended indefinitely with the approval of the parliament every 6 months. The state emergency can be maximum for a period of 3 years. But however, even for that, lot of conditions are there. So normally the state emergency is usually for a period of 1 year, but at a time it is 6 months. Again, if the parliament gives approval, another 6 months. But if the state emergency is to be extended in any state beyond a period of 1 year, then two conditions has to be satisfied. What are the two conditions? First of all, the national emergency should be in the entire country or in any part of that particular state. And secondly, on account of the emergency, the election commission certifies it is not possible to carry out the elections. Only under such a condition, it can be extended beyond a period of 1 year up to how much years? Up to 3 years. So, which of the statements given above are correct? Neither one nor two. Once declared, who has a power to extend the financial emergency? Once declared, who has a power to extend the financial emergency? There is no need to extend the financial emergency, because once it is brought in, it is likely to continue till the time it is revoked. So, therefore, what is the answer? None is the answer. What is the question number? Okay, so none for 358. Come to article 359. During national emergency, the parliament can make laws. During normal times, what the parliament can make law on item in the union list as well as in the concurrent list. But during national emergency, they can make laws on union list, state concurrent list as well as the state list. So, therefore, what is the answer? The parliament can make laws, union list, state and the concurrent list, option B. Which of the following are not necessarily the consequences of proclamation of president rule in a state? Dissolution of state legislative assembly. Okay, anyways, we will see from the options. Dissolution of local bodies. No, local bodies does not. Removal of council of ministers. Of course, it is likely to happen. There is no other doubt. So, wherever there is a 3, just strike it out. So, dissolution of state legislative assembly. Okay, not necessarily. Okay, so not necessarily. Okay, for not necessarily, we will try to see that. Which of the following not necessarily the consequences of the national emergency, consequences of the president rule. So, dissolution of local bodies, no, not does not happen. So, okay, so this has no impact. So, definitely this should be part of the answer. So, 1 and 3 has to be there. Removal of council of ministers, it is definite consequence. So, it should not be part of our answer. So, we will eliminate wherever there is 2. So, 1 and 3 only. Now, why this way also? This is in fact an UPSC question. So, why it is very important for you to understand going from the options that they are given, because they are asking not necessarily a consequence of proclamation of president rule, because once a president rule is imposed, it has to be placed for the approval of the parliament. Until the time the state legislature will be kept only under suspended animation. What if the parliament does not give the approval? Then anyways the state legislative assembly will not be dissolved. So, therefore, not likely a consequence in all the cases. So, that is why this the way the UPSC has asked this particular question. So, what is the answer here? It is 1 and 3 only. Come to the next part, that is constitutional, statutory and the executive bodies, where also you can expect one question from this particular area as well. Shall we move to the next part? Okay. Which among the following commission, is it 361? Okay. Which one among the following commission was set up in pursuance of a definite provisions under the article of the Constitution of India? What is the answer? Very simple. Which article under the election commission? 324 of the Constitution. What about University Grants Commission? What is the status? It is a statutory body. University Grants Commission Act is there, so it is a statutory body. National Human Rights Commission, Human Rights Act is there, it is a statutory body. Central Vigilance Commission, CVC Act is there, it is a statutory body. So, the right answer is only option C. Come to next question. Consider the following: the superintendent's direction and conduct of fair elections, preparation of electoral rolls for all election to the president, state legislature, the office of president and vice president, giving recognition to the political parties and allotting election symbols to the political parties and individuals contesting the election. Which of the above is a function of the Election Commission of India? Which of the above is a function? All are the function. So, this is directly given in the constitution, this is there in the respective acts, the President Vice President Election Act and the Representation of People Act. This is again there in the Representation of People Act. Which of the above are the functions of the Election Commission of India? It is all of the above. Consider the following statements: the functions of the Finance Commission is are to allow the withdrawal of money from the Consolidated Fund of India. It is definitely not the function of the Finance Commission, it is for the function of the Parliament to allow for the appropriation of money from the Consolidated Fund of India. The Finance Commission has nothing to do with this. The approval of the Parliament is required, not the Finance Commission. To allocate between states the shares of proceeds of taxes, yes, that is talking about the horizontal distribution of the states. So, the Finance Commission has two functions, not only the vertical distribution from the center to the states, but also between the states. So, this is definitely there. To consider application of granting aids from the states, no states can make any application to the Finance Commission with regard to the granting aids. It is for the Finance Commission to make a recommendation to the Union government. So, the states are not empowered to make any application to the Finance Commission in this particular regard. Okay. So, this is not one of the terms and references of the Finance Commission. So, this is wrong. To supervise and report on whether the union and the state government are levying taxes in accordance with the budgetary provisions. What about this? This is not the function of the Finance Commission. This is in a way you are making the executives accountable, how they are collecting the taxes. This is the function of the Parliament to see this, and it is not the function of the Finance Commission. Okay. So, this is definitely not there. So, which of the statements given above are correct? What is the answer? No options. Which of the options are correct? Only 2 is not there. How come? Okay, any closest option? What about the incorrect? 2, 3, 4 is there, that is also not there. To allow for the withdrawal of money from the Consolidated Fund of India, no. To allocate between the states their share of proceeds, yes, that is definitely there. To consider application for the granting aids, no, that is not the case. So, which of the statements given above are correct? So, the answer is, okay, just make a small correction, it is only 2. Only 2 is the answer. The other things are not the right thing. Is it clear to all of you? See, the functions of the Finance Commissions will come from 2 areas. One which is directly given in the Constitution. What is directly given in the Constitution? First and foremost is the distribution of tax between the center and the states. The second is to recommend for the granting aids to the states. Third is that they can also give some recommendation to the states with regard to augmenting the finances of the states. So, therefore, they can give more finances to the local bodies, and then any other function which may be entrusted by the President of India also. So, these are the 4 functions which is given in the Constitution. Accordingly, the President can make the terms of references to the Finance Commission. So, this terms of reference might vary from year to year. So, sometimes it may be specifically asked, but otherwise most of the times the question is going to come from what is there in the Constitution of India. So, from the Constitution of India, other things are not the functions. It is only to allocate between the states the share of their proceeds. Which of the following is or correct? In fact, this is a UPSC question, that is why I am thinking why the options are not matching. It's a previous year UPSC question, some few years back. To supervise a report on whether the union and the state government are levying taxes, so definitely 4 is not there, that is not their function. Union and the state governments are levying taxes in accordance with the budgetary provisions. So definitely you can rule out both the things. To allow for the withdrawal of money from the consolidated fund of India, so this is also wrong. So maybe I'll just verify this once again, okay. So maybe it is based on the terms and references. So probably if there is to consider application from the grantee needs, so this I'll have to verify, okay. So please give me some time. So this I'll just verify. So please someone remind me about this question 363, okay. The closest answer, if at all it can be possible, is option 2 and 3. The remaining things are definitely wrong. So 3, it might be on the basis of terms of reference. Article B. Okay, so what it is saying? That is okay, but it is saying to consider application for grant of aids. To consider application, I assume to consider application means the states are making some request to the Finance Commission. Article 275. So what is the clause? Okay. 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 Anyways, so granting aid the center has to give to the state is okay. To consider applications for granting aid. So anyways, I think as per the UPSC key, the closest answer is 2 and 3, but you just give me some time, I will confirm this, okay. So as of now, you can make it doubtful, but you can put 2 and 3 only, because apart from that, the other things are not right, but I will confirm this. It's a very old UPSC question. I think it came in somewhere in 1970s. It's a very old UPSC question. I will verify this, okay. Shows 2 and 3 from where? So true, so okay, 2003 may be repeated. Okay, I think it should be 2 and 3 most likely, but anyways, I'll verify this, okay. Okay, come to the next question. Consider the following statements with reference to India. The chief election commissioner and the other election commissioners enjoy the equal powers but receive unequal salaries. Is it true? So they receive equal, do they have equal powers? Their powers are also same and their salaries are also same, okay. So this is definitely wrong. The only difference between the chief election commissioner and the other election commissioner is with regard to the removal of the chief election commissioner. So the chief election commissioner can be removed in the same manner as that of a judge of a Supreme Court. The chief election commissioner is entitled to the same salary as provided to a judge of a Supreme Court. Is it true? The chief election commissioner is entitled to the same salary as that of a judge of a Supreme Court. This is not given in the constitution, but under the Election Commissioners Act. So this is true. The chief election commissioner shall not be removed from his office except in manner like that of the grounds of a judge of a Supreme Court. Is it true? Yes. So he can be removed in the same manner. So that means what is the ground on which he or she can be removed? Misbehavior or incapacity, and then a motion has to be passed in both the houses, passed by special majority in the same session, approved by the President of India. The term of office of the election commissioner is 5 years from the date upon which he assumes his office till the time he attains 62 years of age. Is it true? It is 6 years or 62 years, sorry 65 years, whichever is earlier. So this is wrong. 6 years or 65 years, not given in the constitution, but as per the act, Election Commissioners Conditions of Service Act, 6 years or 65 years. So which of the statements given above are correct? 2 and 3 only. I think the previous statement, the application from the states, the way that the examiner has given that particular word. So definitely yes, it is the responsibility of the Finance Commission to allocate funds to the states with regard to grantee aids. So the application from the states, I assume that the states can directly make an application to the Finance Commission, which I have not come across anywhere. But is that the meaning, or it is giving a meaning of whether they have to look into how application also means what is the conditions or what is the basis on which the center can allocate states to the center can allocate grantee aid to the states. So if that meaning is there, so definitely 3 is also right. But anyways, right now you just mentioned as 2 and 3. Come to the next question. Which of the following is not performed by the Comptroller and Auditor General? So what is the article that allows for establishment of the CAG? Article 148 of the Constitution. And what are the functions of the CAG? To audit and to report all expenditures from the consolidated fund. Yes. So this is definitely there. So here they are asking not. So we will see. To audit and report all the expenditure from the contingency fund and public accounts. From the public accounts. Yes, because that is also done at the disposal of whom? At the disposal of the executives. So that will also be audited. Okay. Whatever that is done by the government of India, all the accounts of the government of India will be audited. To audit and to report all trading, manufacturing, profit and loss accounts of the government run enterprises. This will also be audited by the CAG. So CAG is an external auditor for the public sector undertaking. To control the receipt and issue of public money and to ensure the public revenue is lodged in the exchequer. So will it be done by the CAG? In fact, I said that the CAG in India is different from the CAG in United Kingdom. In fact, in India, he is only an auditor general. He is not the comptroller. So what is the function of the comptroller is to see whether the money is taken away with his permission only they can take out money, and he will also see whether all the money is getting properly credited into the public accounts. That is not the role of the CAG. Okay, so here this is definitely no. So he has no control over the receipts and the issue of public money. Who will have control over the receipts and issue of public money? The Parliament has no authority over the issue of public money or the receipt of public money. It is done by the executives. The Finance Ministry is responsible. To some extent, the RBI will also have a check over all those things, mostly by the Finance Ministry. Okay. So this is what is you should remember. Consider the following statement regarding the National Human Rights Commission. What is the status of Human Rights Commission? It's a statutory body. Statement 1. Its chairman must be a retired Chief Justice of India or a retired judge of a Supreme Court. Is it true? Yes. Initially, when the law was brought in, the chairman is only a retired Chief Justice of India. But then the problem is there were not enough retired Chief Justices of India to become the chairman of NHRC. So they amended the law and they made it either the Chief Justice of India or any judge of a retired judge of a Supreme Court. So presently this is the law. It has formations in each state as a state human rights commission. Is it true? If you look into the National Human Rights Commission, the Human Rights Commission Act says that there shall be a National Human Rights Commission, and the states may have their own state human rights commission. So it is not mandatory to have a state human rights commission, and there are many states in our country which does not have a state's human rights commission. Most of the northeastern states does not have a state human rights commission. It has formation in each state as a state human rights commission is wrong. So it is not mandatory in the states. Its powers are only recommendatory in nature. Is it true? Yes, they are only a recommendatory body. It is mandatory to appoint a woman as a member of the commission. There is no such mandate under the law. So which of the statements given above are correct? What is the answer? So the answer is option D is the right answer. Which of the following is correct in respect of the commencement of the election process in our country? Please tell me the answer. Okay, tell me what comes first. Is it the election notification or is it the election schedule? Notification or the schedule? And also tell me who issues the election notification. Who issues the election notification for the Lok Sabha elections? Notification in the press conference. Now, who issues the election notification? Is it the Election Commission of India? So, the election to the Lok Sabha is issued by the President of India on the recommendation of the Election Commission of India. So, this is very, very important. As per the Representation of People Act, who has to issue the election notification? The President. Who will issue the notification to the state legislature? The Governor on the recommendation of the Election Commission of India. So, this is what the law says. Okay, now coming to the second question, what comes first, the election schedule or the election notification? First, what comes into place is the election schedule and then comes the notification. So, now the third question is, what about the model code of conduct? Does the model code of conduct has a legal enforceability? Okay, so most of you might know that. But when does the model code of conduct comes into force? Does it comes into force after the election notification or does it comes into force after the election schedule is announced? Notification schedule. The model code of conduct comes into force immediately after the election schedule is announced and continues to be in force till the election results are announced. Okay, so these are all something that you have to remember. Okay, come to this particular question. Schedule, I told. First the schedule, then the notification. First, the election schedule is given by the Election Commission of India. After that, the President will notify only on the recommendation of the Election Commission of India. Okay, so come to the question here. Which one of the following is correct in respect of the commencement of election process in India? So, what is the answer? The recommendation for election is made by the government and the notification is issued by the Election Commission. No, the notification is not issued by the Election Commission. The recommendation for election is made by the Election Commission of India and the notification is issued by the Home Ministry in the center and home departments in the state. No, the recommendation for election is made by the Election Commission and the notification for election is issued by the President and the Governor's concern. Is it true? Yes. Option C is the answer. No, there is no need for any women to be mandatory as a part of. I think you are confusing with certain other thing. There are certain things where there is mandatory requirement for representation from the certain commissions. So, there is no need for any women member per se as a part of this. Okay, so it is not mandatory to appoint a women as a member of the commission. So, in that case we do not have an option. This is again a previous year question. So, even let us assume that if women is to be mandatory, do you have any option to say it right? So, women member is not mandatory, you can just verify that. As per which provisions in the law? You have to check and you have to say it. If you say it something like this, then it is going to disturb everyone in the class. Okay, you have to say with which provision in the law, as not in the internet. That is not. You have to say in the specific law, that is in the Human Rights Act. You will have to go and in which clause, in which section it has been mentioned. Then only it is a valid thing. If you just check in the internet, anybody can write in the internet with the different sources. Therefore, it is going to create unnecessary confusion. So, whenever you are saying something, you just verify it and then you can come and say it. I am willing to change, it is nothing, but there is no other option if you see it here. So, if there is a specific clause, specific section in the Human Rights Act, then yes, then we will have to look for the other answer. Okay, come to the next question. Which of the following are among the functions of the Election Commission of India? So, what is the answer? Statement 1. Conduct of election for the post of Speaker and the Deputy Speaker, Lok Sabha and the Deputy Chairman and the Rajya Sabha. Is it the function of the Election Commission of India? Why it is not the function? Okay, so they don't have nothing to do with the election of the Speaker and the Deputy Speaker. Conduct of election to corporation and municipalities. So, this is done by the State Election Commission. Deciding on all doubts and disputes about arising out of elections. Which of the courts given below? Deciding about the doubts and disputes of elections means there are many elections, nothing is given specifically related to what elections. In fact, they have nothing to do with the state elections. They have nothing to do with what is called as the presidential election. So all doubts and disputes. So this is also wrong. So what would be the answer here? None of the above. Consider the following statement. Statement 1. The member of UPSC or the State Public Service Commission is not eligible for any employment either under the state or union government or ceasing to be such members. What about this? The member of UPSC and State Public Service Commission is not prohibited from further employment, they are only prohibited from reappointment. That means they cannot be appointed to the same post, but there is certain element of further employment is possible. So where they can be appointed? While a member of UPSC can be appointed as a chairman of UPSC, while the member of State Public Service Commission can be appointed as a chairman of a State Public Service Commission or a chairman of some other State Public Service Commission or a member of UPSC. So all these things are possible. So therefore, to say that eligible for any employment, not eligible for any employment is wrong. A member of the State Public Service Commission are appointed and removed by the governor. Is it true? While the appointment is done by the governor, the removal is done by the President of India. So who removes them? It is only the President. So therefore, this is wrong. So what is the ground on which they can be removed? You know what is the grounds on which the members of the Public Service Commission can be removed? What are the grounds on which they can be removed? Proved misbehavior and incapacity is one of the ground. Unsound mind, and if they have become an undischarged insolvent, and if they have engaged in paid employment outside the office. So these are all the grounds on which they can be removed. But however, in one case, the removal has to be referred to the Supreme Court, and only on the basis of the opinion of the Supreme Court they can be removed. What is the ground? Misbehavior or incapacity. So if the question says that they are removed on the same manner as that of a judge of a Supreme Court or High Court, that is not the case. It is only just referred to the Supreme Court for the opinion. The member of UPSC or the State Public Service Commission are removed on the same manner as that of a judge of a Supreme Court. Is it true? No. They are not removed on the same grounds. So this is wrong. So which of the given statement is incorrect? What is incorrect? All of the above. We will try to reach 400. So just I will try to be little faster. Which of the following are the grounds on which the Comptroller and Auditor General can be removed from his office? What is the ground? The Comptroller and Auditor General on only one ground, that is misbehavior or incapacity. Okay. So here misbehavior is there. Okay. So if you say differently, it is misbehavior and incapacity, both the things. So what is the answer? 1 and 2 only. Adjudged and insolvent is not a ground for him. Consider the following statements regarding the Finance Commission of India. The composition of Finance Commission is fixed in the Constitution. Yes, 1 plus 4 members, that is fixed in the Constitution. The qualification of members of the Commission is to be determined by the President from time to time. The qualification is determined by the law made by the Parliament. One of the main function of the Commission is to determine the sharing of revenue between the centre and the states. Is it true? Yes. So what is the answer? Which of the are incorrect? So it is 2 only. So this is one area, very simple question. They just want you to identify whether it is a constitutional body or something. Which of the following is a constitutional body? Tell me, what about the National Commission for Scheduled Caste? Yes. National Commission for Scheduled Tribe? Yes. National Commission for Backward Classes? National Commission for Minorities? National Commission for Women? No. So what is the answer? 1, 4 and 5 only, which is not a constitutional body. What is the article? 338, 338A and 338B. Consider the following. So there are certain terms of references based on which the Finance Commission would decide how the horizontal distribution has to happen. So here what are the parameters followed by the 15th Finance Commission? Demographic performance, yes. Forest and ecology, yes. Governance reforms, stable government, tax and fiscal efforts, yes. Apart from that, what are the other grounds? Population, area and income distance. Now what are those things I am not explaining because there is no time, but if you have any doubt you can ask me after the class, okay. So therefore what is the answer in this case? Only 3. Come to the next question. Consider the following statements. The Election Commission of India is a 5-member body. Is it true? The Election Commission of India is a 3-member body. Is it true? The Election Commission of India is not a 3-member body nor a 5-member body. The Election Commission of India members will be determined by the President from time to time. Suppose if they are asking the Election Commission of India is presently a 3-member body, okay. But what is there in the constitution? The composition is not fixed. It is determined by the President from time to time. So therefore, this particular statement is wrong. The Union Home Ministry decides the election schedule. No, who decides the election schedule? The Election Commission of India. The Election Commission resolves a dispute relating splits and mergers of the recognized political parties. Is it true? Yes, that is one of the function of the Election Commission as per the Representation of People Act. So what is the answer here? 3 only. Come to the next question. Which of the following statements are true regarding the office of Comptroller and Auditor General? The service of Comptroller and Auditor General shall be determined by an act of Parliament and shall not be varied to his disadvantage during his term of office. Is it true? Yes, it shall not be varied to his term of office. The Comptroller and Auditor General shall not be eligible for further employment either under the Government of India or under the state. Yes, constitutionally it is true. He is not eligible for any further employment. That means someone who is retired as a Comptroller and Auditor General, he shall not be appointed in any capacity either under the central government or under the state government. So that is a constitutional requirement. Okay, so this is also true. So what is the answer here? Both 1 and 2. But however, similar restriction is not there for the Election Commission of India. Okay, so it is only for the CAG which is there. Which of the following statements are true regarding the National Commission for Backward Classes? Presently, the National Commission for Backward Classes enjoys a constitutional status by virtue of 102nd Constitutional Amendment Act. Is it true? That is by virtue of Article 338B. After the Commission was given a constitutional status, it has taken away the right of the states to determine their own backward. It has taken away the rights of the states to determine their own list of backward classes, which may not be entitled to get who may be entitled to get reservation in the government jobs. Is it true? Few years back it was true. But after the 105th Constitutional Amendment Act, the situation has changed. So therefore, to answer this question presently, this statement is wrong. So choose the correct answer. So what is the answer? 1 only. Answer the following statements. While the National Investigation Agency NIA, what is the position of the NIA? Is it a constitutional body, statutory body, executive body? It's a statutory body, not extra constitutional. There's a National Investigation Agency Act. Well, the National Investigation Agency has a jurisdiction over the entire country, whereas a Central Bureau of Investigation cannot investigate into the cases in the states without the consent of the states. Is it true? Yes, the NIA doesn't have to take any permission. That's why this NIA Act was also challenged in the Supreme Court, that it is infringing upon the powers of the state, but the law was upheld by the Supreme Court based on the substance, based on the pith and substance, based on the objective of this law. Okay, so this is true. While the National Investigation Agency is a statutory body, the Central Bureau of Investigation is only a body established by executive order. True? Yes. So what is the answer? Sorry, it is incorrect. So neither 1 nor 2. Answer the following statements regarding the model code of conduct circulated by the Election Commission of India during elections. The model code of conduct is a legally enforceable for its violation as it has a strong statutory backing. Does it have a statutory backing? It has no statutory backing. There is no law related to the model code of conduct. That is why it is also criticized as moral code of conduct. The codes come into force as soon as the election notification is issued and remains in force till the conclusion of election. It comes into force after the election schedule is announced by the Election Commission of India and remains in force till the results are announced. Which of the following are incorrect? Sorry, both 1 and 2. Come to the next question. Which of the following is true regarding the National Commission for Scheduled Tribes under the Constitution of India? The commission is established under Article 338A of the Constitution with an objective of safeguarding the rights of the scheduled tribe people. Is it true? It is 338A, not 338B. Yes. So therefore, the statement 1 is wrong. The chairperson. So presently it is wrong. Before the amendment has happened, it was Article 338A and there was only one commission, that is National Commission for Scheduled Caste only, which was looking both the functions, but now it is a separate body. The chairperson and the members of the commission are appointed by the central government on the recommendation of the Parliamentary Committee on Tribal Affairs. Why would the government listen to a committee says in the parliament? So anyways, this is wrong. The appointment is made by the president on the aid and advice of the Council of Ministers. So therefore, this particular statement is wrong. Which of the following is correct? It is neither 1 nor 2. Answer the following statements regarding the Bar Council of India. What is the status of Bar Council? It is a statutory body. The Bar Council of India is established by an executive resolution that regulates the legal profession in our country. Is it true? It is established not by an executive resolution but by law made by the parliament. And what is the act? Which act? Advocates. It was established by the Bar Council of India Act or the Advocates Act. I think it is established by the Bar Council of India Act only, but there is a separate act. Just check it. There is a separate act, Advocates Act, for which also they can make rules. Advocates Act. Okay, it is established by the Advocates Act. Okay, so no doubt. So it is established. Anyways, it is not an executive body, it is a statutory body. So recently the Bar Council of India has framed rules that enables foreign lawyers and law firms to practice in India. What about this? It is part of your current affairs. So recently the Bar Council of India had made rules under the Indian Advocates Act, wherein they are trying to liberalize the foreign law firms also to come and do their practice in our country, and including the foreign lawyers. So this is true. So which of the statements given above are correct? What is right? 2 only. Okay, so please quickly come to the next topic. So we are done with the constitutional bodies also. Now we are entering into the political themes. Again, very, very important. One question is likely to come definitely from this particular area. The Indian parliamentary system is different from the British parliamentary system. How it is different from the British parliamentary system? So in both the cases, there are real and nominal executives. There is a monarch there. Here we have a president. A collective system of responsibility. In both the cases, there is collective system of responsibility. Bicameral legislature. In both the cases, there are bicameral legislature. Even if you do not know the answer, by ruling out, you can arrive at an answer. What is the answer? System of judicial review. How the system of judicial review in India is different from the judicial review in UK? In India, the judiciary can review both the executive actions as well as the legislative actions. Whereas in UK, there the judiciary can review only the executive actions, not the legislative actions. Now, why they cannot review the legislative action? whatever law that is made by the British Parliament becomes part of their constitution. So therefore, they cannot say the constitution itself is wrong. So they cannot review the legislative actions. What they can review is only the executive action. So come to the next question. Which one of the following determines that the Indian constitution is federal? A written and a rigid constitution, an independent judiciary, vesting of residuary powers with the center, distribution of power between the center and the states. Please read all the options. Which is most appropriate? It is distribution of power between the center and the state, but that is protected by an independent judiciary. That's a different thing. But the most appropriate thing is what? Distribution of power between the center and states. Come to the next thing. Which one of the following is a feature common to both the Indian Federation and the American Federation? What is common to both Indian Federation and American Federation? A single citizenship, is it common? They have dual citizenship, we have single citizenship. 3 lists in the constitution. In India, we have 3 lists, they have only 2 lists. Okay, so therefore that is not common. Dual judiciary, they have dual judiciary, but we have integrated judiciary. So that is also not common. So what is the answer? A federal Supreme Court to interpret the constitution. We have Supreme Court of India, they have a court similar to that Supreme Court to interpret the constitution. So therefore option D is the answer. In a parliamentary system, the executives are accountable to, executives are responsible to the legislature. That is very simple answer. So this is the very essence of parliamentary democracy. In fact, this is one area in the last 20 years, at least 15 times they have asked the same thing. What is the essence of parliamentary democracy? In one way or the other, they have asked this particular question. So what is the very essence of parliamentary democracy? That the executives are accountable to the legislature. India is a federal state because, what is the answer? Because there is share of power between the center and the states. Which of the following reflects the most appropriate relationship between law and liberty? Which of the following? So what, for which we will have to have an understanding of what is liberty. Liberty means what? Freedom, if that is qualified in nature, that means if it comes with certain restrictions. So in order to ensure that everybody is having certain rights, so therefore we call that to be what is called as liberty. Now what would be the most appropriate option? You will just try to rule out each and everything. If you are confused also for such things, you try to rule out. If laws are changed too often, liberty is in danger. Does it make any sense? It depends upon the type of law. We do not know what law it is. Maybe the law is enhancing our liberty also in a democracy. So it depends upon what type of law, who is making that law, but that information is not very clear. So therefore you can rule out this. If there is liberty, laws have to be made by for the people. It in fact does not establish any relation between law and liberty. So it is like a separate statement. If there is liberty, laws has to be made by the people. So it does not make any sense. Who is going to make the law? By the people. So nothing is very clear. It's a very vague statement. Rule out this. If there are more laws, there is less liberty. Sometimes more laws means more liberty also. Again, it depends upon the law. So again, you can rule out this. If there are no laws, there is no liberty. Is it true? If there are no laws, then I can do anything. Nobody can punish me for that. If I am powerful enough, I can do anything. I can take away the rights of others. So therefore, laws has to be there in a civilized society to protect the liberty of the people. Okay, so that is very important. So if there are no laws, then there is no liberty. So this clearly reflects the relationship between law and liberty. Okay, somebody has asked me a question of what is the difference between negative liberty and positive liberty. So what is the difference between negative liberty and positive liberty? Does anyone know? Well, negative liberty is seen as some element of protection from the authority of the state. That is negative in character, that is negative for the state. But positive liberty is positively which is allowing an individual to develop himself. That is what is considered to be positive liberty. Okay. So the answer is option B here. Democracy's superior virtue lies in the fact that it calls into activity what? What is the answer? intelligence and character of ordinary men and women, that is what is democracy. So it is intelligence and character of ordinary men and women, so that is the most appropriate thing for democracy. That means everybody shall have the right to vote, everybody shall have equality, so that is what is about democracy. In the context of polity, which one of the following would you accept as the most appropriate definition of liberty? So what is the most appropriate definition of liberty? Absence of restraint. So absence of restraint. So liberty is not absence of restraint. There can be reasonable restrictions. So this is not the answer. Opportunity to do what one likes, whatever one likes, then there is no restriction in it. So that is also not the thing. Opportunity to develop oneself fully. This is more similar to the concept of what is called as positive liberty that just now I discussed. Positive liberty. But anyways, we have to rule out. This is the right answer, but you'll have to rule out option A also. Protection against the tyranny of political rulers. Now, protection against the tyranny of political rulers will not only amount to what is called as liberty, because liberty means an individual should also be protected not only from the rulers or someone who is in position of authority, but from the social sanctions also, from the social pressures also. So it is not talking about all those things. So here the most appropriate thing which talks about liberty is the statement D. So therefore this is also wrong. I have left out. What is 387? The intelligence and the character of ordinary men and women, that we have already discussed. Okay, come to the next question, 388. Out of the following statements, I am just checking how much time we have got. Okay. Out of the following statements, choose that one brings out the principle of underlying the cabinet form of government. What is cabinet form of government? Cabinet is basically a collective decision making body. So the very idea of having cabinet in a parliamentary democracy to ensure what is called as the collective decision making. The most important decisions of the government are collectively made. It is not for any other purpose, and therefore collective decision making will also enhance the accountability of the government. It is not to speed up the decision making. It is, in fact, it can delay the decision making, collective decision making, but it will make the system more accountable. Okay. So what is the answer? A mechanism in a parliamentary democracy to ensure collective responsibility, and therefore the system becomes more accountable to the people. No, ask. No, even with the council of ministers and cabinet, if you see, the cabinet is no way going to speed up the process. If the council of ministers system, we follow a portfolio system. So in a portfolio system, who is supposed to be in charge of a particular ministry? A particular minister. So therefore, in that case also a particular minister can easily take the decision rather than taking up the matter for the cabinet. The cabinet has to come, meet, discuss. Therefore, anyways the cabinet is not much faster than the council of ministers also. But still we follow the cabinet system. It is because to make the system more accountable. That is the idea of the cabinet system. We come to the next question. In the context of India, which one of the following is the characteristics appropriate for bureaucracy? So which is the character appropriate for bureaucracy? It has nothing to do with widening the scope of parliamentary democracy, nothing to do with the strengthening federalism, nothing to do with also agency for political stability or economic growth. The most important function is to implement the public policy. So tomorrow when you become part of bureaucracy, what is the important function? To implement the decision that is taken by the political executives, be it laws or any of the other policies. First you will have to implement. This is the most appropriate thing. It may have an effect on certain other things also, but what is your primary responsibility is this. A parliamentary system of government is one which, what is the answer? The government that is responsible to the parliament and can be removed by it. Okay. A government which is responsible to the parliament and can be removed by it. Okay. Do you have any confusion with the other options? Political parties in the parliament are represented, not all the political parties are represented. The government is elected by the people, this is true, but not removed by the people. So therefore it is wrong. The government is chosen by the parliament but cannot be removed by it before the completion of the fixed term. Can they be removed? Yes, they can be removed even before the completion of the fixed term. A constitutional government means, what is the answer? What is a constitutional government means? A government which is limited by the constitution. So basically what is a constitutional government or what is constitutionalism? Is a government which functions as per the constitution, that is the constitution is implemented in letter and spirit. And in most of the democratic constitution, if you see, there is limitation upon the powers of the state. So that is one of the important feature to restrict the functions of the government. So what is the answer here? Government that is limited by the state. This is also one question which is repeated 4-5 times in the last few years. A constitutional government is a limited government. Answer the following statements. A constitutional government is one which places effective restrictions on the individual liberty in the interest of the state authority. No, rather it should be vice versa. So it is not restricting of the individual liberty in the interest of state authority, but it places effective restrictions on the authority of the state in the interest of the individual liberty. So what should be the answer? 2 only is the answer. Which of the following best explains the concept of liberty? Freedom to do whatever one wishes to do, then that becomes freedom, which is absolute in character. So therefore that is not the answer. Set of rights and privileges given to the members of a society subject to arbitrary restrictions. It cannot be arbitrary restrictions, it should be reasonable restrictions. Set of rights and privileges exercisable member of a society subject to reasonable restrictions. Yes. So the answer is option C. Which of the following is not a representative system of checks and balances? Okay, there is a difference between separation of powers and the system of checks and balances. Can anyone tell me what is the difference between system of separation of powers and checks and balances? Okay, no problem. So what is the difference between separation of powers and checks and balances? I think we are trying to explain the difference between separation of powers and division of powers. Okay. How they are interconnected to one another? Are they interconnected? One organ has some element of control over the other organ. Okay, so the next question is, do you think in India there is a complete separation of powers? Our system, is it based on a strict separation of powers? Our constitution is not strictly based on the idea of separation of powers. That does not mean that there is no concept of separation of powers, but most importantly it is based on the principle of checks and balances. Now why separation of powers mean what? Separation of power means different organs, they have the respective domain, respective functions, and one shall not interfere with the functioning of other. So in order to prevent and to control one authority to become too arbitrary or too powerful, there is some element of control which one organ can exercise over the other organ. That is basically what is called as checks and balances. So the Constitution of India is not strictly based on the principle of separation of powers, but rather it is relying upon the idea of what is called as checks and balances. Now why there is no strict separation of powers? Because there is overlap with regard to functioning of certain organs. Where there is an overlap? Legislature and the executive. In fact, in all the parliamentary democracy, there will be an overlap between the legislature and the executive, because the executive ultimately come from where? From the legislature. So therefore, that overlap is there. But even between the legislature and executive, there is a system of checks and balances. How the checks and balances are there? Because the executives are accountable to the legislature. Only for the legislature there is no much problem, but the legislature, the members of the parliament can also be disqualified by the president. So who can disqualify them? The president can disqualify them. So there is a system of checks and balances. See that the law made by the parliament can be struck down by the court, and if you see the judges are functioning arbitrarily, they can be removed by the president, by the parliament, and then of course by the president. So in this way there is some element of what is called as checks and balances. So now come here. So with that you just try to answer here, which one of the following is not a representative system of checks and balances under the Constitution of India? What is the answer? So somebody has answered C, then you have got the idea of what is checks and balances. So checks and balances is always control of one organ over the other organ. Some student are asking me, why sir, anyways the council of ministers are having control over the president, but both are executives here. That is the idea. So checks and balances should be one organ over the other organ. Okay. So shall I move to the next question? Come to the next question. So remaining, I think it is very clear in the other question. Executive accountable to the legislature, two organs are there. Removal of judges by the president, two organs are there. Judicial review of courts over the legislature and executive, different organs are there. The only thing where there are only executives is option C. Okay, so therefore this is not the right answer. Okay, come to the next question. Which of the following is true regarding the concept of judicial review? So how is judicial review different from the review powers? Clear? So judicial review is the power of the judiciary to look into the action of other two organs. Review power, its own judgment. Which article is for judicial review powers? 137, which also provides for what is called as curative powers. What is article 136? Special leave petition. Okay. So what is the answer in this case? It is a power of the judiciary to question both the actions of the legislature and the executive for violating the provisions of the constitution. Consider the following. Schedule 7 of the constitution, all India services, integrated judiciary, parliament unilateral power to create or admit new states, state public service commission. Which of the above are reflecting the principles of federalism under the constitution of India? So what are the factors that reflect federalism? What about schedule 7? Yes, it provides for division of powers, all India service. It's an unitary feature, we already discussed this. Integrated judiciary is also one unitary feature. Independent judiciary is a federal feature, but integrated judiciary is a unitary feature. Parliament unilateral power to create or to admit new states, that is not a federal feature. In fact, the states are not given any power in this regard. State Public Service Commission, how many of you think it is a State Public Service Commission? State Public Service Commission allows the state to recruit their own agency, but there is some element of criticism there also. Although they recruit the officers for the state, I would say this is right here, but anyways, even for the members of the State Public Service Commission, they can be removed only by the President of India. Those states do not have any authority in this regard, but anyways, considering the nature of function, it is a federal provision. So what is the answer here? It is 1 and 5 only. Both independent and integrated. So that I have many times explained in the class. So what is the difference between independent and integrated judiciary? Independent judiciary means the judiciary is independent from the other two organs of the state, that is from the legislature and the executive, that is independent. While integrated judiciary means there is a single hierarchy of judiciary. So at the apex we have the Supreme Court, and then below that we have high courts, and then below that we have the subordinate courts, and all these courts are free to interpret both the state laws as well as the central laws. That is basically what is called as integrated judiciary. An independent judiciary, while the judiciary is performing their functions, they are free from control of the other two organs of the state, that is independent judiciary. Is it clear? Okay, come to question number 399. Which of the following best explains the term democracy? Which explains best the term democracy? Direct rule by people, is it democracy? That is also democracy, but it does not explain, because there is indirect democracy also. It does not completely explain. Rule by legitimate authority. In North Korea, there is also some ruler is ruling. So that is a legitimate authority there, but all legitimate authority cannot be considered what is called as democracy. The government in which supreme authority is vested in the people and exercisable by them either directly or indirectly. So this is the complete definition of democracy. So come to the last thing, last question. Which one of the following best explains the term secularism in the Indian context? Which explains secularism best in the Indian context? Complete separation of state from religious matters. Is it true? So in India, we do not have a strict separation. State have official religion but treat every religion equally. We do not have any state religion. State respect all the religion equally but can make positive interventions in the matters of religion. Is it true? Yes, the state can make positive intervention, none of these. So the right answer, the most appropriate answer is option C. So with that, we have done with what is called as the political themes as well. So just give me a couple of minutes. So what are the themes that you have covered from the beginning? Starting, we have covered from the Constituent Assembly, we have covered the preamble, we have covered the Union and its territories, we have covered Union and its territories, then we have covered the citizenship, fundamental rights, DPSP, fundamental duties, and then we have covered the entire executives, we have covered the entire legislature, judiciary is done. What else has been done? Center state relationship is done, and after center state relationship, local bodies are done, municipalities and panchayats, and then you have done constitutional bodies, then we have done emergency provisions also, political themes are also done. Almost 13 to 14 questions are covered. But what is still pending that I wanted to do is, especially one is this historical underpinnings. There is a possibility of one question that is coming from that particular area. Schedules, important articles, amendments, schedules, and then certain miscellaneous topics. But however, this is my last class, so probably I am not sure that I will be able to take that, but what I can do is, if it is permitted, I am ready to do it, but as far as whatever has been informed me, this would be my last class. So probably what I will do is, I will share the entire question paper with the answer key. You please go through those things, and in any case, any questions for any of those things, you can reach out to me. You can reach out to me, I will give the answer for that particular question. Okay. Question number 3, that is, I'll just come. So if you want to reach out to me, you can reach out to me through this. I usually respond in WhatsApp, so you can drop me a message in the WhatsApp. Okay. It's okay. What they will do with my number? Huh? Ultimately, I can respond or not respond. If so, it is for me to decide. So that is not an issue. So the last question paper, 100 questions, which will cover the historical underpinnings, schedules, important amendments, the miscellaneous topics also. So you just go through the questions, and the key is also given. For any question, if you have problem with regard to the explanation, you can reach out to me. Okay. All right. So normally I don't pick up the calls, but you can drop me a message and then you can call me. Okay, in case if you want to connect with me. All right. So with that, I'll wind up the class. What is the question? 360. Give me the question paper. In 2019, as per the which provision? No, these things you just go to the law, and from there you should. The website, NHRC website. Which section? Just let us change it. So what could be the appropriate answer? What about the states? What is the question number? The chairman must be a Chief Justice of India or the retired judge of the Supreme Court. It has formation in each state of State Human Rights Commission. So what about each state is having a State Human Rights Commission? Many of the states in India are not having the State Human Rights Commission. that as per the which it has formations in each state, but there is a specific clause that I have read under a specific section, I do not remember the section. It says that every state may have a state human rights commission. So as per the legal words, if the word shall is used, then it becomes mandatory, but not the word may. Shall, after the amendment or in the original act? After the amendment. So probably after the amendment, but these are all very old questions actually. So anyway, so some of the changes has been made. So from that, each it has a formations in each state. So statement 2 should be right after the amendment. Statement 4 I am coming. So the powers are only recommendatory in nature. So that powers are only recommendatory in nature is also true. So it is mandatory to appoint a woman as a member of the commission. What is the section? So just read the language, if not the section. This is after the 2019 amendment. Okay, so therefore statement 4 is correct if that is the case. So then what is the answer that we can arrive at? So the only option that you are left with is 1, 2, 3 and 4, but not all the states are having even today the State Human Rights Commission. Some of the states are not having it, but maybe as per the law they should have it, but some of the states have not done it probably. Okay, all right. So the answer you can change it to option D. Okay, option D is the answer. But whenever you come, you just come out with the provisions. Okay. Huh? Okay. Okay, no issues. So with that, we'll wind up the class. So the last thing is it will be shared, but if you have any doubts, you can reach out to me. And thank you very much, and all the very best for your examination. Okay.